We're live.
Good afternoon. This is the House Judiciary Committee. It is the 22nd of February, 2022, 2/22/22. And we have a full docket of bills today. All of them are 3 minutes and 2 minutes, 3 minutes for the sponsor, 2 minutes for any witnesses that are there. And we're going to start with House Bill 959, Delegate Novotny. The sponsors on this, it's Delegate Novotny and Vince McAvoy. We'll hear from both of them. 3 minutes for the delegate, 2 minutes for Mr. McAvoy. So if you'd like to begin, Delegate Novotny, go right ahead.
Thank you very much. Good afternoon, Chairman Clippinger and members of the committee. My name is Delegate Reed Novotny, representing Howard and Carroll counties. This is a bill to increase the safety of our children in schools. There's no more important issue than keeping our children safe when they are in the care of our state through our schools. A friend of mine approached me with this loophole in the way we treat individuals of power in our school systems a few years back. As the statute currently reads, a person in a position of authority in our schools must be employed by the school directly or through a contract to have this statute apply. As a proud and slightly overprotective dad of my daughter, Vienna, I do not want to have a predator walking free because of a technicality. It is a problem with our law that needs to get fixed to keep our children safer in schools. What I propose is expanding the person of authority to include those people who work in other capacities within our schools. The parents of the child who is taken advantage of should not care if that person of authority who took advantage of their child is an employee, a contractor, or however they get their paycheck. This, in my mind, is an easy and needed fix for our school safety. I want to thank you for your time and ask for a favorable report. Thank you, Mr. Chair.
Vince McAvoy, is he here? No, Vince. Okay, we're going to go ahead and take questions for Delegate Novotny. Are there questions for the delegate? Delegate McComas?
Okay, Mr. Chair, thank you. And if I'm out of order, please let me know. I just was kind of thinking, older kids may go and help the children at grade school level, if they're doing soccer or things like that, somebody that's, maybe 18, 19 or 17. And I was wondering if basically, 21 is the bill still says 21, correct? You have to be 21. And I think that basically a person of authority could be just an older kid. And I just kind of, if you want to protect the kids, I'm thinking maybe somehow try to clear up that loophole. That's all. And I could be out of order. So I know the chair will let me know.
Mr. Chair, could I address that really quickly?
Please, yes.
Okay, thank you, Mr. Chair. Thank you for the question. When I was drafting this bill, it obviously was something I spoke with DLS about, how to define a position of authority. And basically the intent of the bill was when it's a place of work, right? So volunteers are covered in different statute. This is really where someone is there as their full-time job. And the question came up too, for example, what about a mail carrier, FedEx or USPS, who does work there? And this does not cover those type of people. And I don't believe it would cover your example either when someone was volunteering. So this is really when it's their job to be there the majority of the day, the most of the day. So Mr. Chair, if that answers the question, thank you.
Further questions for Delegate Novotny? All right, seeing none, we thank you very much. And that'll conclude the testimony on House Bill 959.
Thank you, Mr. Chair.
Thank you. We'll go now to House Bill 863 and Delegate Terrassa, who is joined by Benjamin Streifel and Jeff Gillerin, please. So if I could hear from Delegate Terrassa, please. This is again 3 minutes. 3 minutes for the delegate, 2 minutes for everybody else. Is she here? She was here. She's in her. There's somebody there. Delegate Terrassa?
Yes, sorry about that. I'm
all
here.
Right.
Thank you, Mr. Chairman. Yes.
Yeah.
Thank you, Mr. Chairman, and members of the Judiciary Committee. Thank you for this opportunity to present House Bill 863. For the record, I'm Delegate Jen Terrassa. Because of a series of regulations and departmental guidance, stemming from current Maryland code, criminal defendants are being denied the right to fair trial because they are unable to question the results of state forensic labs. And in some cases, they are unable to have expert witnesses testify at trial. The Maryland Department of Health is responsible for licensing of forensic labs. Health General 172A04 states a forensic laboratory shall hold a license issued by the secretary before the forensic laboratory may offer or perform a forensic analysis in the state. An unlicensed lab may be granted a letter of exception. This is a little complicated, but you guys are used to complicated, I'm sure, but may be granted a letter of exception by the Secretary of MDH to perform limited forensic analysis if it meets the exception requirements set by the Secretary. MDH took it a step further through its Office of Healthcare Quality and promoted regulations that require individuals who perform forensic analysis but are not affiliated with a state lab, basically, to obtain a letter of permit exception. Not only that, but MDH also requires this letter for individuals who are merely reviewing results or conclusions of the original analysis. This essentially means that state lab employees can perform analysis on forensic evidence, but those that do not work for state labs must seek a letter from the state to review the work of the state lab. This creates a problem for defendants seeking to have an expert review analysis performed by the state lab in preparation for trial. The problem goes even further. Some trials have interpreted the regs to mean that in order to testify in court on behalf of defendant, the forensic expert has to obtain a letter of exception. In other words, these judges are interpreting the laws and regulations to mean that whether an expert has a letter of exception is a threshold question, rather than the judge making that determination of whether the expert is qualified. The bottom line is MDH should not have control over whether an expert can testify against them. And it might make sense for them to be able to control who goes into their labs, but not who can look at their reports and testify against them. And ultimately, this means pretty much nobody can testify against them. House Bill 863, I'm running out of time, simply fixes this by prohibiting the Secretary of Health from requiring a letter of exception for an individual to testify in criminal proceedings who is reviewing the data, opinions, interpretations, and conclusions of another expert or forensic laboratory and is not handling any physical evidence. I respectfully urge a favorable report. I think that was all my time, right?
Benjamin Streifel, please.
Thanks. I'm Ben Streifel. I have a PhD in chemistry from Johns Hopkins. And I've been working with the Public Defender's Office for 5 years or so, reviewing drug documents from the crime labs. So I am in favor of this bill. I urge a favorable vote as well. This rule is absolutely preventing people from testifying on behalf of criminal defendants. I have been excluded from trial for not having the letter in a case where the judge otherwise recognized that I was perfectly qualified to be testifying about the subject. So that defendant went without an expert. This has happened at least one other time. Joe Bono, who is the president of the American Academy of Forensic Sciences at the time, and he was excluded from trial as well, simply for not having a letter. There's no forensics testing being done by myself. This law doesn't affect that, the quality of any forensics testing or anything like that. It merely allows people to review the evidence presented against them in court. As it stands now, there's no exception for attorneys or defendants. You are not allowed to interpret your drug testing evidence without this letter. And since 2016, nobody in Maryland has had this letter. So for the past several years, the state has run unchallenged in court, and I don't believe that's very constitutional. You should be allowed to review and challenge that with expert testimony. This affects minority groups particularly, who are overwhelmingly arrested more frequently for drug violations. So by preventing anybody from challenging this, you are further disenfranchising those people. And so that's bad. This is a relatively simple fix. This just allows you to review the documents. It doesn't change the analysis at all. It doesn't change anything about defense experts going into labs and say, looking at shoe prints, that's still protected. You need a letter to do so. And that's my time. So it's low risk, high reward.
All right, thank you very much. We'll hear now from Jeff Gillerin, please, for 2 minutes.
Good afternoon. As the Chief Attorney of the Forensics Division, I'm responsible for retaining experts for public defender cases. The public defender requests that this committee issue a favorable report on House Bill 863. The requirement for a letter of exception was intended to safeguard the integrity of physical evidence while in the custody of a crime lab. But in the vast majority of cases, experts retained by the defense don't handle physical evidence. Instead, they simply review a crime lab's reports and data and provide opinions about the validity of the lab's conclusions. And under those circumstances, there's no danger that the evidence will be contaminated or harmed. So the requirement for a letter of exception is unnecessary. But critically, this requirement interferes with the defendant's right to present a defense. And here's why. The decision whether an expert is qualified to testify is a different matter than safeguarding evidence from incompetent handling. The decision must be left to the court's discretion, not to an administrator who is in no position to determine whether an expert meets the requirements of Rule 702, given the specific facts and circumstances of a case. But unfortunately, this regulation has led some courts to prevent qualified defense experts from testifying simply because they either don't have or have been denied a letter of exception. Such a situation infringes on a defendant's right to choose an independent and qualified expert to testify on her behalf. And this should not happen. It could lead to a miscarriage of justice by preventing a defendant from exercising her right to due process. None of us want an administrative regulation to act as an impediment to the defendant's right to present a defense. If this regulation is not amended, the integrity of our criminal justice system will be compromised. It's imperative that the language of the regulation be modified to ensure that the decision about whether an expert is qualified, her conclusions have a sufficient factual basis, and whether her testimony will assist the jury be left in the hands of the proper party, which is the presiding judge. Thank you.
Are there questions for this panel? All right, seeing none. That concludes the testimony on House Bill 863. We thank you all very much for your testimony today.
Thank you.
Thank you.
All right. We'll hear now House Bill 940. House Bill 940 is Delegate Shoemaker's bill. We'll get Shoemaker, Elena McWilliams. Oh, I'm sorry, they're unfavorable. So we'll just go with Delegate Shoemaker and then we'll hear the opponents. Delegate Shoemaker, go ahead for 3 minutes.
Thank you, Mr. Chairman. This is a bill that I did bring forth during the 2020 session. Of course, what we know about life since 2020 is that we've been in the throes of a pandemic for a substantial period of time since, and the issue of porch piracy has only been heightened since I last brought this bill. So what this bill does is it imposes heightened penalties for those who steal packages from the residence of the intended recipient. Currently, there aren't any state laws on the books specifically designed to deter the notion of package theft. We know statistically, my intern did some research that says, although package thefts have affected many Americans during quarantine, this type of burglary isn't an isolated problem. An estimated 44% of Americans have had their packages stolen at some point, most commonly from right outside their front doors or on their porches, which is a particularly invasive way, I would submit, to be victimized by a crime because they're coming up onto your property. So that compounds the issue for a lot of these victims. In the last year, more than 57% of stolen packages were delivered by Amazon. We know, of course, that in the wake of the pandemic, Amazon deliveries have grown exponentially. as people have ordered stuff instead of going to brick and mortar stores. We know, according to the statistics, that 49 million Americans have had at least one package stolen in the past 12 months. I think that was from the security.org. A lot of legislatures, I mean, I'm not reinventing the wheel. I'm not coming up with something that's unheard of, but legislatures across the country are fighting back with statutes specifically addressing package theft. Arkansas, Georgia, Michigan, Oklahoma, Tennessee, Texas have already passed porch pirate laws that carry tougher penalties or make repeat offenses into felonies. And essentially that's what this does. It adds heightened penalties. Violators are guilty of a felony, punishable by imprisonment for up to 5 years and or a maximum fine of $5,000. Of course, this bill is within the province of this committee now at this point, my new committee that I'm happy to be on. So if you all want to tinker with the sentencing component, then you can have at it. So thank you, Mr. Chairman.
Thank you. Are there questions for Delegate Shoemaker? Right. Seeing none, that concludes the testimony in favor of the legislation. We'll hear the testimony against the legislation. Nicole Hanson-Mundell and Elena McWilliams. Wondering if they're here. Elena McWilliams is here. Ms. McWilliams? All right. For 2 minutes, please, Ms. McWilliams. This is House Bill 940, Ms. McWilliams. Please begin for 2 minutes.
Hello, my name is Elena McWilliams. I work for Out for Justice, and I am also a researcher who has published scholarly articles on criminal record discrimination. This bill plays to city dwellers like me who fear getting their packages stolen. However, the consequences of this political power play will be disastrous for people who face these added consequences. We know that increasing consequences for crimes does not reduce crime. We've had decades of research that shows incarceration rates are not related to crime rates. We also know that increasing somebody's label from misdemeanor to felony actually increases their risk of recidivism. We also know that this is the same old Southern strategy that politicians have used for 80 years, wherein they hype up fear of crime in the inner cities, and then they pose themselves as the solution to that crime to gain popularity. This is an ineffective strategy. We know better. We should do better.
Nicole Hanson-Mundell, please, for 2 minutes.
Thank you, Mr. Chair. My apologies. Organizations like myself, we have to do the work on the ground and do the work in Annapolis. Thank you. My name is Nicole Hanson-Mundell, Executive Director of Out for Justice. I think we are opposing this bill. This bill plays, like Elena said, into the fears. Increasing consequences will not reduce these crimes. We know that harsher sentences do not reduce crime. Studies show. And so what we want to make sure is that being charged with a felony as opposed to a misdemeanor for the same crime really increases the likelihood of someone recidivating. And I really want to make that point clear. And I know my 2 minutes is almost up, but I concur with the comments of my fellow staff member, Elena. And so we're asking to strongly oppose this piece of legislation. Thank you, Mr. Chair, for your patience.
Thank you. Are there questions for this panel? Seeing none, we thank you both very much. And that concludes the testimony for House Bill 940. We thank you for your testimony there. We'll go to another bill now for Delegate Shoemaker. It's House Bill 948. And we'll go ahead and hear from Delegate Shoemaker, James DeWeese, Christopher McMillan, please. 3 minutes for Delegate Shoemaker, 2 minutes for everybody else. And Delegate Shoemaker, when you're ready, go right ahead.
Thank you, Mr. Chairman. I don't generally introduce a whole lot of proposed legislation, but when I do, I try to make them comport with common sense and simplicity, because I'm a simple fella. House Bill 948 is both simple and common sense. The Carroll County Sheriff and personnel of his office called to my attention that a loophole exists in the law, and HB 948 seeks to close that loophole. What it does is it generally prohibits a registrant on the sex offender registry from providing informal child care to a child who does not reside with the registrant. A registrant may provide informal child care to a child who does not reside with the registrant if, one, the registrant promptly notifies the parent or guardian of the child that the registrant is required to register, and two, that the registrant has been given specific written permission by the parent or guardian to provide informal child care to the child. I found that there was a loophole in my bill to close the loophole, which is why there is an amendment, sponsor amendment that may or may not be in your packet presently, that says that this proposed legislation would apply to a person who is a sex offender, regardless of whether they're a registrant or not, because there are some folks who have been convicted of sex offender type offenses that aren't required to be on the registry. So it would close the loophole within the legislation to close the loophole. And with that, I would turn it over to my sponsor panel to address the impetus behind the bill, which is a situation that arose in my county. So thank you, Mr. Chairman.
All right, Sheriff DeWeese, please.
Thank you, Mr. Chairman. I appreciate it. Good afternoon, members of the House Judiciary Committee. I'm Carroll County Sheriff Jim DeWeese. I appreciate you giving me a few minutes to speak on this very important bill, and I am speaking in favor of it and the amendments. As sheriff, I oversee law enforcement and corrections for Carroll County with a staff of around 300 personnel. As part of my law enforcement operations, I'm responsible for registering, monitoring, and tracking all sex offenders in Carroll County that are court ordered to the Maryland Sex Offender Registry. Registrants are categorized by tiers. They go from tier 1 to tier 3, with tier 3 being the most serious offenders. Carroll County currently has 146 registrants on our list, with 86 tier 3 offenders, our most serious offenders. Master Deputy Chris McMillan is my deputy that diligently and respectfully works with each registrant so they comply with the law, but also can lead productive lives. He does a fabulous job, and I often get emails and letters from registrants on how professional Deputy McMillan is. In February of 2021, Deputy McMillan brought to my attention a specific case he was working on that exposed a potential loophole that existed for offenders to continue preying on young children through babysitting services. As with any law that is written and enacted, circumstances arise that aren't foreseen, and legislation is needed to amend the law so it continues protecting all those that it was designed to protect. And with that, without going into great details over that particular February 2021 case, I'll let Deputy McMillan do that and explain why we are asking for this particular legislation.
Deputy McMillan, go ahead.
Good afternoon, members of the Judiciary Committee. Thank you for giving me this opportunity to express my thoughts on House Bill 948. My testimony today is favorable with amendments. I would first like to thank Sheriff DeWeese, Delegate Shoemaker, and his aide Molly, and all the delegates that sponsored this bill. For without these individuals, the creation of this bill would not have happened, and we wouldn't be discussing it here today. My hope here today is that we can close what I feel is a loophole in our current law as it relates to Maryland convicted sex offenders and their current unrestricted ability to perform informal child care services in the state of Maryland. My name is Christopher McMillan. I'm a Master Deputy at the Carroll County Sheriff's Office with 20 years of service. In that time, I've been assigned to various units to include corrections, patrol, undercover narcotics, and sex crimes. I'm currently the supervisor of the Carroll County Sheriff's Office Sex Offender Registry Unit, and as such, I am responsible for 146 registered sex offenders in Carroll County. I'm passionate about my current assignment. I take my duties very seriously. On February 23rd of 21, a Carroll County resident responded to my office, visibly upset. She was upset because she had recently become aware that the individual that she had entrusted to provide child care for her child between February of 19 and March of 20 was a convicted and registered Carroll County sex offender. Needless to say, the complainant was not aware that her child care provider was a convicted and registered sex offender. The complainant was a friend of the registrant. On February 23rd of 21, I confronted this registrant in question regarding the allegation, and she admitted to babysitting the complainant's child for $10 an hour, 22 to 23 hours a week. The child care was provided in the registrant's home. Maryland Title 13A defines informal child care as relative care, in-home care, and babysitting. Relative care is care that is provided in the relative's or the customer's home by a relative and is exempt from licensing. In-home care is provided to the customer's children in the customer's home by a non-relative and is exempt from licensing if all children being cared for live in the residence in which the care is provided. Babysitting is care that is provided in the babysitter's home for unrelated children for less than 20 hours a month, for which state law exempts the babysitter from being licensed. In the case of the aforementioned Carroll County sex offender registrant in question, she was providing child care in her residence from February of 19 to March of 20 for an unrelated child that far exceeded 20 hours a month, which according to Maryland law Title 13A requires a license. The registrant did not have a license and could not have obtained one thanks to Maryland Title 13A. In Maryland, convicted sex offenders are prohibited from working at licensed child care facilities and licensed child care homes. In Maryland, convicted sex offenders are prohibited from obtaining a license to open a child care facility or a child care home. This got me thinking, what if the registrant in question had babysat the complainant's child for less than 20 hours a month, which does not require licensure? Does Maryland have any laws prohibiting convicted sex offenders from providing informal child care as previously defined? I could not find any, and based on my research, there is none. This means that a convicted sex offender could provide child care to the customer's children in the customer's home if all children being cared for live in the residence. This also means that a convicted sex offender could babysit in their own residence for unrelated children as long as the babysitting stayed under 20 hours a month. If the state of Maryland prohibits convicted sex offenders from working at licensed facilities, and if the state of Maryland prohibits convicted sex offenders from opening their own licensed regulated facilities, then why does the state of Maryland not prohibit convicted sex offenders from performing informal child care, especially since children are more vulnerable in an unregulated setting? Initially, I had some concerns with the original bill that Delegate Shoemaker had sent over. We addressed those concerns, and he sent over some amendments to that bill. I took a look at those amendments, and what
he may have talked so fast that I think he broke the internet. I'm not sure what happened there. But Deputy,
he was trying.
Well, he is, and that's fine, Sheriff. I can certainly see his passion. Not making light of it. That those are the witnesses who are here to testify on the bill. Hopefully, Deputy McMillan hasn't totally gotten knocked off the call yet. Do people have questions for Delegate Shoemaker, the sheriff, or the deputy? There we go. Delegate Grammer.
Thank you, Mr. Chair. Just a quick question. Can someone refresh me what the definition of informal childcare is? It seems we talk a lot about that. Specifically, can you define that for me? Because we talked about a couple different types of childcare, and I just want to understand specifically what we're speaking to when we talk about informal childcare.
Give Delegate Shoemaker the opportunity to check his notes here. I believe though the deputy mentioned a definition Can
you hear me?
Yeah,
sir.
there you go.
And great. That's fantastic. So the question
Go
was
ahead,
about,
Deputy.
yeah, the informal childcare. We were looking for that definition. Go
It's
ahead. Deputy.
defined in the law. Go ahead, Deputy.
I'm sorry, did you hear me?
Yes.
Yeah.
I apologize. I had some technical difficulties. So the Delegate Shoemaker, I got what you had sent over with my concerns. And I think what you sent over as an amendment to your initial House bill was great. I would just get rid of the does not reside with sex offender part and just put in there is related to that informal child care to a child that is unrelated to the sex offender. Because the thing is, if you had a sex offender who allowed an unrelated party to move into their residence with children,
Right.
then as long as that child lives there, then they could provide the informal child care to an unrelated child, and that wouldn't be good.
That's a good segue. So Delegate Grammer asked the question, could you provide him with how informal childcare is defined in the law?
I'm sorry, there was a volume issue, Delegate. Could you repeat that, please?
How is informal childcare defined in the law? That's Delegate Grammer's question. Can you answer that for him?
Yes, I can. So under Title 13A, informal child care means child care.
We cannot accept this amendment in the attached.
Dylan.
Please go ahead with the definition.
Please go ahead with the definition.
I apologize. Maryland Title 13A defines informal child care as follows. Informal child care means child care that does not require the child care provider to be licensed or regulated under Maryland law and is limited to relative care, in-home care, and babysitting. Now, those definitions under Title 13A are as follows. Relative care is care that is provided in the relative's or the customer's home by a relative and is exempt from licensing. Under our current amendment, that wouldn't be an issue. If they wanted to babysit or care for relatives, that's fine. In-home care is provided to customers' children in the customer's home by a non-relative and is exempt from licensing if all children being cared for live in the residence which care is provided. I would prefer that be prohibited because that would allow a convicted sex offender to go into an unrelated party's home and babysit their children, which I don't think is a wise idea. Babysitting is defined as care that is provided in the babysitter's home for unrelated children for less than 20 hours a month, for which state law exempts the babysitter from being licensed. Again, I would feel that this type of childcare should not be undertaken by a convicted sex offender for obvious reasons. You know, you're opening up a situation where somebody could easily reoffend with an unrelated child.
Does that answer your question, Delegate Grammer?
It indeed does, and I appreciate everybody contributing.
Thank you.
Delegate Cardin has a question next.
Thank you, Mr. Chairman. This is, I think, for Delegate Shoemaker, probably. You may want to refer it out. But so my understanding with how this bill is, and we can talk about the amendment that was suggested later if we need to, but if you have somebody who is a registered sex offender because of a, let's just say for the sake of argument, a third degree, maybe even a fourth degree sex offense against an adult, it's possible with that amendment that was just suggested that they couldn't then be an in-house caregiver to a baby. If we pass that amendment, but you could be an in-house, you could be a babysitter to a teenager. Is that my understanding of how the bill would be if we passed it with the amendment that was just suggested?
I think that's probably accurate. I'll have to think about that and talk to you about it.
I'm all about, let's figure this one out.
Yeah. Okay.
We just got to make sure that we know what we're doing here, but yeah.
Exactly.
Okay.
I'll talk to you about that, Delegate Cardin.
All right. Seeing no further questions, Thank you all very much for coming to testify today. That's the testimony on House Bill 948. We thank you all very much for your testimony. Thanks.
Thank you.
everyone. All right. Delegate Davis had a bill 997 that she has withdrawn. So we are going to go now to House Bill 920. Delegate Bartlett. We'll hear from Delegate Bartlett, Lila Meadows, Elizabeth Hilliard, Kim Haven, T.S. Braveheart, Yanet Emanuel, Elena McWilliams, and Nicole Hanson-Mundell. We'll just hear from all of them and go from there. Delegate Bartlett for 3 minutes, everybody else for 2, whenever you're ready.
Thank you. Mr. Chair, Vice Chairman, and colleagues, I am presenting House Bill 920 on correctional services, medical parole, life imprisonment. The intent of the bill is to essentially repair a technical oversight and repeal that remaining portion of the statute that involves the governor in the parole decision-making process. Because as you all may recall, in the 2021 special session, the General Assembly voted to override the governor's veto of Senate Bill 202. Therefore, the law was enacted that correctly leaves the decision within the exclusive power of the Maryland Parole Commission to grant parole to an inmate serving a term of life imprisonment with the possibility of parole. A person sentenced to life imprisonment without the possibility of parole.
I'm sorry, Delegate Bartlett, your
Yes.
microphone is not picking you up terribly well. And it's
Okay.
very difficult to- That is better. Whatever you've done right then seems to work a little better. But
I also turned up my volume. Does that help too?
that seems to help. That seems to help very much. So sorry, go ahead. Sorry to interrupt, but yes.
You want me to continue or just start over?
Why don't you start over? That's fine.
Okay. All right. Well, colleagues, I'm presenting House Bill 920, Correctional Services, Medical Parole, Life Imprisonment. And the intent of the bill is essentially to repair a technical oversight and repeal the remaining portion of the statute that allows the governor in the parole process. Because as you may recall, in 2021, in our special session, the General Assembly voted to override the governor's veto of Senate Bill 202. Therefore, the law was enacted that correctly leaves the decision within the power of the Maryland Parole Commission to grant parole to an inmate serving a term of life imprisonment that was sentenced to life imprisonment with the possibility of parole. A person sentenced to life imprisonment without the possibility of parole is not eligible for parole consideration and may not be granted parole at any time during the inmate's sentence. I just want to make that part clear. Although they may be eligible for pardon or commutation by the governor. House Bill 920 addresses medical parole. I submit that given the decision of the General Assembly in the 2021 special session, we should also leave the exclusive power of medical parole decisions with the Parole Commission, thereby removing the need for the governor to approve, consider, or disapprove the Parole Commission's decision. Medical parole was established in 2008 because the General Assembly recognized the need for incapacitated inmates who, as a result of a medical or mental health condition, a disease or a syndrome, or pose no danger to public safety, and having served a certain amount of their sentence that entitled them to be considered for parole, may be released. The law changed in 2017 to give the final decision to the governor to disapprove the commission's decision or to let the decision stand by doing nothing. Given the passage of Senate Bill 202 in the 2021 special session, I do not believe it was the intent of the General Assembly to bifurcate the decision of medically eligible inmates between the Parole Commission and the governor. Having said that, and given the little to no opposition to this bill, I humbly request the committee to provide a favorable vote for House Bill 920. Thank you for your considerations, and I'm around for questions.
Lila Meadows, please, for 2 minutes.
Good afternoon. My name is Lila Meadows, and I'm a clinical faculty member at the University of Maryland School of Law. For several years, I've represented individuals in the parole process, including individuals who are serving life sentences and including individuals who are seeking medical parole. As Delegate Bartlett mentioned, I really view this bill as a technical fix. The General Assembly finished the work that had been ongoing for so many years to remove the governor from the parole process and vest that final decision-making authority with the Maryland Parole Commission, where it properly belongs for individuals who are serving life sentences. Through what I believe was an oversight, that bill didn't include language that would strike the governor from the section of the code, section 7-305, that included medical parole. I want to be clear that when we're talking about individuals who qualify for medical parole, the legal standard is that someone essentially has to either be terminally ill or be so incapacitated that they're incapable of posing a danger to public safety. The types of clients who I've represented who qualify for medical parole are people with advanced stages of cancer, people who have had so many strokes while in the Department of Corrections that they're wheelchair bound, they're unable to walk, they're wearing diapers in the facility. And so we're talking about people who are really, really sick. And so it makes sense. It's consistent with this body's action that the Maryland Parole Commission would have final authority over whether or not those folks meet the criteria for medical parole and should be released. Keeping the governor in this process creates significant delay, which is something that folks in this condition really can't afford, and it doesn't do anything to improve public safety. And so I would urge a favorable report on this bill. Thank you.
Elizabeth Hilliard, please.
Good afternoon. Thank you, Mr. Chair, members of the committee. Elizabeth Hilliard, Assistant Director of the Government Relations Division in the Maryland Office of the Public Defender. I basically just want to say we agree with everything Lila just said. We view this as a technical fix to ensure that folks who qualify for medical parole do not have to have their applications further delayed by awaiting gubernatorial approval. It makes sense. I have had clients pass away who were slated for medical parole, and the parole commission had recommended medical parole, but the governor's office was unable to process their applications in time. It doesn't make sense for someone to die alone in a prison cell or in a prison hospital, which I would say from my personal experience is worse, when they have family members and hospice care available to them, and the only thing that is standing in their way is too much time for the governor's office to get to their case and to prove everything. This just makes good sense, and it closes a very important loophole that was left out last session. So we urge a favorable report on this bill. Thank you.
No, Kim Haven. T.S. Braveheart, please. You're muted.
Are you calling me, Mr. Chair? Nicole?
There we go.
No.
All right. Sorry
Go
about that.
ahead,
Thank you.
Braveheart. Yes.
Yes. Hi, I'm Tisha Keena Braveheart with the Justice Policy Institute. Over the last decade, JPI has released over a dozen policy and research reports on the Maryland justice system. And we offer this testimony today in support of House Bill 920. During the debate on the bill to remove the governor from the regular parole process, we heard how the Parole Commission is much better situated to evaluate someone for release due to their history of involvement with the incarcerated population. The governor was making decisions based off no interaction with the population whose fate he was deciding. So the idea of making uninformed decisions on medical parole recommendations is actually unfathomable. It's already extraordinarily difficult to be granted medical parole. The Maryland Parole Commission is not lenient, as demonstrated in the case of Donald Brown, a wheelchair-bound, partially paralyzed, diabetic, amputee, stroke victim with a brain injury and dementia, who was initially denied by the Maryland Parole Commission. And when they did grant his second petition, he passed away within 4 days. Had the governor been involved in that process, Mr. Brown would have most definitely died in prison So please understand that placing medical parole decisions solely in the hands of the Maryland Parole Commission will not open the floodgates. As mentioned, unfortunately, due to a technical error, the bill to remove the governor from parole did not remove him from the medical parole process. The same logic and considerations that went into the passage of last year's bill should be applied to removing the governor from medical parole. There is no legitimate policy goal, least of all protecting public safety, which would support keeping the governor in the medical parole process. So we ask for favorable consideration of House Bill 920. Thank you.
Thank you very much. Janet Emanuel, please, for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. For the record, my name is Yanetta Emanuel, Interim Public Policy Director at the ACLU of Maryland. Last year, the General Assembly voted to remove the governor from the parole process for persons serving life sentences. We are extremely grateful for the work that this committee did to ensure that that bill passed and in a strong posture. So I want to thank you all for that. And you've heard already from all of my colleagues stating why this bill is important and is just simply a technical fix. So I will not repeat that. And I will just say that it was clear that it was the legislator's intent to pass this bill to remove the governor completely from the process. And this HB 920 just simply seeks to fix that error. And that the need for the parole commission to be able to act expeditiously is arguably most crucial in those cases where the parole candidate is seriously ill or dying, as my colleagues already discussed. And so for the foregoing reasons, the ACLU of Maryland urges a favorable report on HB 920, and I'm happy to take any questions. Thank you.
Elena McWilliams, please, for 2 minutes.
Hello again, my name is Elena McWilliams, here representing Out for Justice. I'm urging a favorable report on House Bill 920. Everything has already been well said by my colleagues, but I would just like to add that I was a mental health provider for several years in Baltimore City and saw numerous people released for incarceration with severe medical issues and severe mental health issues. And although many have not had direct contact with people who might be released under this bill, with
police departments in Maryland have gone far beyond the government-controlled databases like driver's licenses and mugshots, and are currently working with vendors who are using private databases. Vendors have downloaded all of our publicly available social media photos from Facebook, Instagram, etc., and they're contracting with police in Maryland to look for criminal suspects out of this private social media data. So let me be clear. It is not my goal to legalize police use of facial recognition. If I'd had my way, this probably wouldn't be happening. And I think that would be true of Sednor Sidnor too. But it's already happening with no restrictions whatsoever. So this bill attempts to set a few basic ground rules to not allow this to be used as evidence in court, to limit the types of crimes that you could use this for, to crimes of violence, human trafficking, or substantial public safety or national security threats. And on this last point, it's a little bit unsettled. The bill attempts to limit which databases you can search to the private government databases. And I know that there's law enforcement resistance to that because, as I mentioned, police departments in Maryland and in my Montgomery County are currently running searches on people's private social media. So there's a lot to talk about there. I'll stop and turn it over to the panel. Thank you.
All right, we'll hear from Mr. Giannetti now for 2 minutes, please. Mr. Giannetti, you're muted. Mr. Giannetti, you're on mute.
There, now I'm okay. Great, thank you.
2 minutes.
Thank you, Chairman Clippinger, Delegate Moon, members of the committee. Thank you for letting me address you. I'm John Giannetti. I'm coming from the Maryland Criminal Defense Attorneys Association. We stand in favor of this bill, recognizing, first of all, applauding Delegate Moon for trying to take a big bite out of an apple here. We recognize that there's a lot going on with this bill. And I think that if you tried to go to the mat on any of the individual items, that you might be able to find problems with them. But whenever you're dealing with a new technology, you as a legislature have some important roles. Sometimes it's a new technology, you want to facilitate new technology. And then at the same time, after it's being used, you want to limit it. And I think this bill falls in the latter category, where we know that this is already being used and to what end. And I think, Delegate Moon should be applauded for his attempt and Senator Sidnor for trying to do this. I think ultimately we're endorsing the idea that there should be some limits on the use of this technology. I think the delegate made a very nice suggestion saying that it can only be used not as final evidence and not as sole evidence for the basis of a warrant and only in preliminary hearings. And ultimately, we might decide that this technology is trustworthy enough to be able to be used in other circumstances. I think we all want to use technology to make our societies safer. However, we don't want to give up civil liberties. So we'll let it stand at that. We believe in the sanctity of this bill, the idea that it's going in the right direction. Thank you very much, members of the committee. Mr. Chairman.
Nathaniel Erb, please, for 2 minutes.
Thank you, Mr. Chairman, members of the committee. My name is Nathaniel Erb, here on behalf of National Innocence Project in support of HB 1046. The work of preventing wrongful convictions is too often that of hindsight. 32 people in Maryland so far have been exonerated. In response, this body has adopted several policy reforms to address the factors that led to those wrongful convictions. This is one of the few times we can act proactively. We have found mistaken eyewitness identifications to be the leading cause of wrongful convictions. Facial recognition technology is often reported to solve this issue by taking the human factor out. However, as the stakeholders who worked on this legislation discussed, this is not yet the case. Human biases, particularly along racial lines, can be baked into the technology and the underlying source material. There simply isn't yet adequate training to ensure accurate identifications. Further, reliability has improved, but there is significant variance in the efficacy amongst different vendors. Budget constraints, deceptive marketing, and other forces encourage the use of less reliable systems across the state. The question before this committee is not only whether facial recognition is a useful tool, but is a necessary tool, and one our communities want us to sacrifice their privacy for. Are the risks associated with it worth it? And if so, what protections put in place are enough? The technology may help identify people in the most heinous of crimes, but the question remains, are those reliably the right people? In some of the first documented wrongful arrests related to this technology nationally, the misidentification of innocent people by facial recognition even overrode other exculpatory evidence. While it may not happen in every case, the cases of wrongful convictions show how tunnel vision can set in and be exacerbated by this technology. We support HB 1046 because Maryland must protect its citizens by reining in and making public these technologies. This technology may one day be helpful in preventing wrongful convictions as it purports to be, but we do not yet have that confidence that it is. We encourage the committee's continued examination of this issue and updating these provisions going forward. We also support amendments proposed by the Office of the Public Defender and the NAACP Legal Defense and Education Fund. We want to thank Delegate Moon and Senator Sidnor for extremely long and arduous work on this legislation. As my colleague said before, I think there's probably places you could point holes in about everything, but it's a strong step forward, and we would request the committee to pass it. Thank you.
Before I call the next witness, apparently the live stream for the Judiciary Committee had cut out for a moment on the General Assembly's website. If members are getting messages about this, you need to, if you're watching on the live stream, just make sure you refresh your browser and it should be working again. It did appear to have only cut out for a couple seconds, but it apparently left some technological challenges in its wake. All right, we'll hear now from Drew Northrup.
Thank you, Mr. Chairman. Good afternoon. My name is Drew Northrup, and I'm an attorney with the Forensics Division of the Office of the Public Defender. And our position on this bill is favorable with amendments. I would just like to echo what Delegate Moon, Senator Giannetti, as well as Nathaniel Erber already have said, and more eloquently than I can. We also want to thank Senator Sidnor for his persistence and determination, as well as Delegate Moon for their grappling with this issue, which is no mean feat, bringing all the parties together to work on this bill, which is an important first step for this area, which is currently unregulated. And as Delegate Moon said in his testimony, the future is now. We are seeing cases with this. And I can say that we have seen cases in the Public Defender's Office using this technology with varying degrees of oversight. And so the important things here, the restriction to its use to the most serious crimes, the need for additional evidence to establish probable cause, and the transparency requirements will help to foster a more measured and responsible use of this technology. However, I said with amendments because after working on this bill and talking to other people about it, there was things that sort of were implicit understandings among the people who wrote this bill that may not be implicit to people outside of this. And so consequently, we have just offered some amendments, specifically ensuring that the discovery provisions do in fact cover this, so we are entitled to the discovery in this matter, also ensuring that it does not come in to a criminal trial under any circumstances. And finally, also ensuring that any sort of developmental validation or studies about the efficacy of these are available online for everybody to see, so that there's full transparency, because needless to say, use of facial recognition breeds mistrust. But at the end of the day, it's important to recognize that this technology is new and the standards for its use are still being developed. And so as our understanding in this area of science grows and standards are implemented, this legislation will almost certainly need to be revisited to incorporate these developments. Nevertheless, this bill is an important first step to regulate this area of technology with a high potential for misuse. And we're tendering to both sponsors amendments that we believe address the concerns that we have set forth above. Thank you for your time.
All right. Owen Larder, please, for 2 minutes.
Thank you, Chairman. And I wanted to start with a big thank you to Delegate Moon and Senator Sidner for their leadership on this really important issue. I'm Owen Larder, I'm representing Microsoft, and there's 3 main points that I'm really trying to get across. Firstly, as we've heard, that facial recognition is a new and powerful forensic tool that is already being used and for which we now urgently need new law. Second, that this bill represents a really important step forward, which we support, in ensuring that police can use facial recognition, but only in a way that is rights respecting, transparent, and accountable. And third, that the bill can be strengthened further by requiring testing of facial recognition systems. So we at Microsoft believe that facial recognition offers real benefits to society, but we also acknowledge that there are potential risks it creates, particularly in relation to bias and unfair performance, new potential intrusions into people's privacy, and potential threats to democratic freedoms. And so that's why in addition to us having enacted some internal safeguards, we are advocating urgently for the need for new law, particularly in relation to police use of the technology, given the consequential nature of the types of decisions that the police make. And so on this front, we feel like the bill represents a real opportunity for progress. We also agree that there are strong civil liberty protections in there about when facial recognition can and can't be used. The ban on invasive mass surveillance is positive on this front. There are some really important transparency and accountability measures, including on reporting and auditing, and stipulating the precise databases which police can search with facial recognition. And there's also important elements on human review. We do, however, think it can be improved with 2 types of testing. Firstly, in relation to third-party testing. So we think vendors should enable legitimate and reasonable third-party testing of their systems. That's because there's a real variation in the range of performance of different vendors. So third-party testing helps identify the best performing systems, and it also builds public trust in the tech. And secondly, we also think there is a need for operational testing, because environmental factors like camera positioning and background have a really big impact on system performance. So testing to identify gaps and then address them is really important so that we can ensure that police are using technology that is effective and technology that people can also trust. So thank you very much for the opportunity to testify.
All right, thank you very much. Are there questions for the panel? See Delegate Cardin to begin. Delegate Cardin, please.
Thank you, Mr. Chair. Very quickly, this is, I think, for Mr. Northrup or former Senator Giannetti. As fellow defense lawyers, can you just expand on how this technology is being used inconsistently in different jurisdictions? Maybe give me an example of, is it easily thrown out? Mr. Northrup, have you found it easily thrown out because of inconsistency, or do you find judges in certain jurisdictions or prosecutors in certain jurisdictions are using it more than others, that we need to create some predictability and stability in the system?
Well, I mean, I'll tell you sort of what I've come across is, I mean, there's examples of it being used with additional evidence, which I think may be, shall we say, more suitable. I mean, I'll give you an example of that. There's a case out of, jurisdiction in Southern Maryland where they had, there was a woman, took a lot of money out of the bank, and then was followed out of the bank and then was robbed by an individual. And this individual she didn't get a good look at him, but she got a good look at his car that was fairly distinctive. And they used facial recognition software to identify an individual in line behind her at the bank. And then they found out this individual happened to drive such a distinctive car. And then they actually went and talked to that individual and asked him about whether that was him or not. So that would seem to be more appropriate use, where there's another jurisdiction where was a shoplifting case where they literally charged somebody based upon facial recognition and nothing else. I mean, they didn't even go talk to this person, and they just basically, this person found out from their probation officer that a warrant had been issued for their arrest. And so consequently, they were sort of brought in solely upon that. And the issue is sort of like, it's twofold. I mean, but first of all, even assuming that these algorithms are perfect, which they're not, the fact is that individuals do very badly at identifying facial recognition. That's something that needs to be sort of recognized right off the bat, that we like to think that we're better at it than we are. And the fact is that facial recognition is only a skill that's only been developed in the last 100 years with the advent of photography. It's typically when we identify an individual, we're looking at their entire body. So this is a relatively recent adaptation that we've had to make, and we're still not very good at it. So consequently, we have to recognize all of these things. And so what happens is that as a result, it really shouldn't be brought in as evidence. However, what happens is that somebody might say is, well, we're not going to bring it in as evidence, but we're going to show the video and we're going to have the individual there. So the jury will make the decision. And the problem is that's incredibly suggestive and very problematic, which is why there's a provision in this to require, if you're going to establish probable cause, you need other independent evidence, like maybe the car that somebody was driving, maybe the clothes they were wearing, or something along those lines. I hope that answers the question.
Are there further questions for the panel? I have one, and I've started to go through the bill once, and I'm sure I'll be reading it a couple more times, but I want to go to on page 3, sort of 16 through 25. A police officer or other employee or agent of a law enforcement agency may not, in furtherance of a criminal investigation, and this is my question, focuses on the word analyze an image or recording of an individual. And I understand 1 and 2, and I get that part, but analyze an image or a recording of an individual who is not intended to be identified. Analyze feels kind of broad in that context. Maybe I'm misreading it and need to read it in broader context of the bill, but does that mean that an officer looks at a picture or listens to a recording and happens to identify somebody else, and now they can't use that because they just sort of happen to be in the right place at the right time? Or I don't know whether I'm over analyzing it, but I guess my hang up might be over the word analyze, because I see the
Mr. Chair, I say there might just be a drafting inconsistency there. If you look at page line 26, the terminology changes and says use facial recognition technology to analyze. So I think that just might be, I mean, there's been a lot of rounds of this one going on.
I got it, and maybe that's what it is it wasn't consistent through there, and so I was kind of wondering what, whether there was a distinction there with the use of the word analyze. But with that, there's a lot more probably, but I will leave it at that for now. All right, are there any further questions regarding, for this panel, at least for House Bill 1046? All right. Fortunately, we will not now hear about how Mr. Northrup and I went to college together, and we'll conclude the questions for this panel and hear the panel in opposition to the bill. You all had your chance and you didn't know. Oh, well, maybe next time. All right, thank you very much. We'll go to the panel in opposition. Kevin Metcalf, Scott Schellenberger, Brian Carney, Tom Williams, and Jacob Parker. We'll hear from them for 2 minutes each.
Sorry, it's very hard to watch on one computer and come into the other.
We all appreciate it. So hang on a second. So we'll, I just want to make sure we've got everybody in the room. So I see you, Mr. Schellenberger. All right, so we'll take you first. So Mr. Schellenberger first for 2 minutes, then Mr. Metcalf, Carney, Williams, and the 5th person, Mr. Parker. So go ahead, State's Attorney Schellenberger.
Good afternoon, members of the committee. Scott Schellenberger, State's Attorney for Baltimore County. I was very, very troubled about whether to sign up favorable with amendments or unfavorable with amendments. Vice Chair Moon and Senator Sidnor have done a great job. We are so close to being there. There's still just a couple more changes that law enforcement felt like we needed to have. I know Delegate Moon and Senator Sidnor wanted to get this draft out, but there were still a couple of little changes that need to be made. But here's the progress that we've made over the work group. We decided to limit the laws that we could use this one. We matched it up with crimes of violence, which is a good standard by which we use. We're trying to make some changes by agreeing that you can't do live time or real time identification unless there's an imminent threat. It modified the training requirements. We believe that we need to use the state police as the agency that's primarily responsible for this. We agreed that there should be statewide policies and procedures and maintenance of records so that you can just go to one place to get all of these things done. Obviously, we've made a lot of progress from the other couple of years where I came in here and said, don't do this. And so I'm going to continue to work with Delegate Moon and Senator Sidnor and with my other law enforcement partners to get this down to a bill, but we are very close to being there. And I have every confidence that we can get a bill with reasonable restrictions through this year and finally be done with facial recognition statutes. With that, I'll defer to my others.
All right, Mr. Metcalf, for 2 minutes, please.
Yes, thank you. I had submitted written, so I won't go into too much. Just a quick background. I have spent over 30 years in law enforcement, either state and local, federal, or military, primarily worked in counterterrorism. But over the last 8 or 9 years, I've been a prosecuting attorney and really focused on child crimes. And I can tell you that your investigators who work anything dealing with child crime, especially child exploitation, this is often the last resort, the last play that we've got. We've exhausted every other method. This one comes in, and you definitely need one that is open source, not closed like just the driver's license database or arrest records. I'm going to be speaking on this at Interpol next month in France, and I'm also scheduled to teach at CPOL, which is at the International Cybercrime Academy in June. So this is an international question and of interest internationally. I also lead a team of international law enforcement that work with private technology professionals, and I can tell you, you are well on your way to setting the safeguards and the guidelines. Facial recognition technology can be used responsibly and effectively, and it's possible to do that. Plenty of agencies have proven that. And I applaud your ability to move forward on this and set up these safeguards. But I will say that the problems with facial recognition technology are one of human. It's a human problem, not technology. Technology is constantly going to change and adapt. You definitely have to focus on the human aspect. This cannot be probable cause. It will always be lead or intelligence only. We'll say that this has been used to recover hundreds of children that would otherwise have gone unnoticed last year, including one who was led us to an offender in California who is currently abusing children under the age of 4. Thank you.
All right, thank you very much. Brian Carney, please, for 2 minutes. Brian Carney. Mr. Carney. All right, well, we'll come back to Mr. Carney. Let's go to Tom Williams, please.
Mr. Chairman, can you hear me?
Yes, go ahead for 2 minutes.
Sorry about that. I'm getting some feedback from the system, but let me try to turn that off.
Yeah, you got to just turn off the YouTube link and then we'll be fine.
All right. How about now?
Sure.
Okay, fantastic. Well, I'm Tom Williams. I'm with the Maryland State Police. And like my colleague, Scott Schellenberger, we believe that we're pretty close on this legislation. We do believe that this is technology that should have some restrictions on it. We participated in the work group with Senator Moon and with Delegate Moon and Senator Sidnor, and we believe we have a great partnership moving forward. We've been doing this now for almost 4 months, 5 months. But I agree, we're really close. We've submitted a number of amendments to Delegate Moon through the group that we've been working with. And we do believe that we're close, but there are some problems, as I said, with the bill. We have recommended that some of the things in the bill maybe be struck. One of the issues you've heard is about the access to the images. Well, one of the reasons we agree to limiting what kind of cases and how this evidence can be admitted was because we realize it's not perfect. When you talk about sole evidence, we don't want this to be sole evidence. We want it to be an investigative tool. That's really what we're looking for here. This technology has been around for years. We agree with limitations on its use, and we certainly agree on some of the things in this bill, but the bill does a lot more that we believe is detrimental to investigations. And so to the committee, we say, and to Delegate Moon, we want to work with you. We certainly want to work to maybe get a few more amendments in this thing, but we agree that we are close. But unfortunately, there's some detrimental pieces to this bill, which kind of make this, you're essentially limiting the use of facial recognition technology when it could really be used to benefit victims, suspects, and law enforcement investigations. So I'll leave it at that. You have our written testimony, and I'm available for any questions.
All right, let's now hear from Brian Carney, please, for 2 minutes.
Good afternoon, Mr. Chairman and committee members. I apologize for the technical difficulties. Thank you for asking me to speak today. I'm Anne Arundel County Police Lieutenant Brian Carney, a current CID commander. I'm here on behalf of the Maryland Chiefs of Police and Sheriff's Association to oppose House Bill 1046. For the last 6 months, we worked with the bill sponsor and other stakeholders to craft legislation. Unfortunately, after much spirited discussion, we couldn't agree on the bill. We remain committed to work with the sponsor and stakeholders to keep Maryland safe. As written, House Bill 1046 restricts facial recognition use and takes away current capabilities. For example, a single facial recognition technology in the bill limits queries to only mugshot or driver's license photos. This is problematic. Not everyone has booking photos or government ID, and it prevents us from generating leads. During investigations, police query other images as bulletins for missing persons or suicidal persons or persons of interest. The bill stops that. Use limitations impact our ability to solve human trafficking and child sex crimes cases, many of which are online. What if someone posted threats, plans to kill, or crime photos on publicly available open sources? We couldn't use those images. Cases like the US Capitol arrest, Parkland, Florida, Pulse nightclub, and the Pittsburgh Synagogue mass shootings would negatively be affected. What about the dark web? Bad actors recruit there, share your personal information, spread hate, and plan crimes there. This bill stops us from using those images. What's the risk versus reward? We see no benefit. Currently, the abuses are balanced with the privacy and protection of civil liberties. We support appropriate safeguards on a policy development to assure proper use. For years here in Maryland, the technology has been used successfully. It was used in the Capitol Gazette shootings and other cases. As of today, the U.S. has seen 10 school shootings and 64 mass shootings. Maryland has had 90 homicides and 192 non-fatal shootings so far. Public safety is nothing to gamble with. This should motivate us to remove harmful limitations. With that said, we respectfully request your unfavorable report for House Bill 1046. I'll be happy to answer any questions you may have.
All right, now we'll hear from Jake Parker, please, for 2 minutes.
Mr. Chairman, members of the committee, Jake Parker here with the Security Industry Association located in Montgomery County. We're a trade association of security and life safety technology providers, including the leading providers of facial recognition. I was pleased to also participate in the work group hosted by Vice Chair Moon and Senator Sidnor before the session began. We support having rules in place that ensure this technology is only being leveraged in a way that is lawful, effective, accurate, and non-discriminatory. On the one hand, our communities have benefited from effective use of these tools by Maryland investigators for over more than a decade without a single verified instance of misidentification or misuse, and every indication that it's being used in a bounded way. On the other hand, significant public concerns have been raised about how the technology might be misused in the absence of specific rules and statute in the state. My understanding of the bill is its intent is to address this by putting in place measures that establish that competence. We support many of the key limitations of the bill, for example, ensuring potential match results are never used as the basis to arrest someone or something that could be used against someone in court. We also support the complete transparency the bill would provide by ensuring agencies publicly report what technologies they're using what data, as well as exactly what they're using it for, the extent of their use in annual reports, and also establishing a statewide standard for law enforcement policy. However, as the other panel members have mentioned, we think as written, the bill goes too far with some of its provisions by taking proven tools out of the hands of Maryland law enforcement. These provisions, like limiting investigators to a single technology platform and data source, limit the current ability of investigators to analyze criminal records from other jurisdictions and also open source information that they already have access to and can search in other ways. This is particularly important in cases involving child sexual exploitation, or where suspects or victims have no criminal records or from out of the area. As we saw last year, these tools were used to define many of those that attacked the US Capitol. It would also limit one of the key benefits of the technology, which is to help limit human bias in police work, and also to address the flaws in eyewitness technology that we also heard about earlier in presentations. The latest research shows that trained humans working alongside the tool as an assistive measure is the most accurate way for the identification process to occur. As a Marylander, I think unnecessarily hampering the ability of law enforcement in my community to do their jobs without a really good reason it really just bothers me. However, these issues can be fixed with a few changes, as the others have mentioned, and we would have the strongest law in the country that puts safeguards on facial recognition while ensuring the proven benefits continue. I urge you not to approve the bill in its current form, and happy to answer any questions you might have.
Thank you very much. Are there questions for this panel? Delegate Bartlett had one, but does not have one now. Delegate McComas does, though. Delegate McComas.
I'll make this short. My question to the panel that feels that this bill needs some either modification or is not quite ready. It seems to me that we have a lot of reluctance by witnesses to testify or to come forward with information, and I'm kind of thinking that this is not really going to be, this is basically the beginning of an investigation as to where you start looking into something, as opposed to this is, going to charge the person or going to be used by the prosecutor to prove beyond a reasonable doubt. So I just would like you to comment on that.
So, Delegate, you are correct. This is a tool. Just a tool to be used in the investigation. Like we said, we've agreed that the fact that there was an ID should not come into evidence, that it's not solely the basis for the arrest. So it's just one little cog that kind of just gets you in the right spot. But you are correct. It's not the whole case. It's just a piece of the case.
Thank you.
Further questions for this panel? Seeing none, we thank you very much. And that concludes the testimony on House Bill 1046. Thank you very much. We're going to go now to Delegate Stephanie Smith and House Bill 1011.
Hello, Mr. Chair. How are you?
I'm fine. Quite a few people to testify here. So we'll go with Todd Oppenheim, Brian Levy, Christopher Dews, Nicole Hansen Mundell. We'll stop right there and then we'll go on to the next panel. Actually, no, that's fine. We'll do that as the first panel and then we'll go from there. So Delegate Smith for 3 minutes, please.
Thank you so much. Thank you, Mr. Chair. For the record, my name is Delegate Stephanie Smith, and I'm here to present House Bill 1011. Greetings, Mr. Chair and Mr. Vice Chair and all members of the committee. As you may recall, last year, you passed a bill that I brought before you related to pretrial detention in terms of home detention monitoring as an alternative, particularly as we were concerned around crowding in jails in general, and then also what COVID presented as another form of danger to those who have not been convicted of any crime but are simply awaiting their proper day in court. I want to just kind of, highlight some of the challenges for those who are not before the committee last session, is that you have folks that are arrested that are awaiting their opportunity to go to court that oftentimes are already in a precarious economic situation. And when you have to spend upwards potentially of hundreds of dollars a month to be able to leave pretrial detention, that can pose a significant hardship. So this committee and the MGA passed a law that said if you're an indigent defendant, then you would no longer have to pay those home detention monitoring fees, because we did not want you to simply be in jail because you are poor. We wanted you to be able, if you're eligible for home detention monitoring, to be able to utilize it and return back to your community in safety. This was a big lift. We were fortunate to have funding committed to this, but also we had to find a home for the actual application of these funds to the home detention monitoring companies. And there stepped in the Maryland Judiciary. The judges are determining who's eligible for home detention monitoring, and it seemed it would be efficient for them to also apply funds accordingly to those eligible for the program. This is not the usual in Maryland, but it's not unusual in other parts of this country. We also, in the bill that was passed last year, established a work group to look at sustainable long-term systems for facilitating this type of a program. Unfortunately, without the governor identifying everyone that was needed to participate in that work group, it was not seated. What this bill would do is extend the opportunity to actually have that work group, have it operational, require annual reports to the MGA, but it would extend last year's bill through 2025 so that we could have data to really get a better understanding of the scope of this challenge, but also have proper time to work with stakeholders both in the MGA and outside to determine a long-term sustainable system. But I do want to commend the reluctant judiciary for really pulling together in record time and government time a program that has so far been working pretty efficiently. But I do know that there was some hesitation to take on this role in the interim, but I believe it advances justice, not only in this moment, but through 2025 for this program to be administered and processed by the judiciary to ensure that those who are eligible for their fees to be assumed by the state, that is done so. And it also gives us all adequate time to ensure that we have a long-term solution. So I thank all of you for the opportunity to present House Bill 1011, and I do request a favorable report. Thank you, Mr. Chair.
Thank you. Todd Oppenheim for 2 minutes, please.
Good afternoon, everyone. The Maryland Office of Public Defender asks us that this committee issue a favorable report on House Bill 1011. The OPD supports the bill. No one awaiting trial, presumed innocent, should be incarcerated as a result of their financial circumstances. However, prior to October of 2021, if you couldn't afford pretrial home detention fees, you generally couldn't get it even if a judge allowed it. Once on home detention, if you missed payments, you could be rearrested. If HB 1011 is not passed, these injustices will reemerge. HB 1011 merely seeks to continue the General Assembly's successful efforts from last year in passing legislation, which came out of this committee in regards to pretrial home detention inequity. Because of a new law in 2021, money became available in October to go towards pretrial home detention fees for poor defendants. From my perspective as an attorney of 18 years with the Public Defender's Office, this has been one of the most impactful actions for our clients to help them pre-trial. You'll hear from proponents, including home detention companies themselves, yes, we are allies in this effort, who will speak of the system's successes. I've seen injustices firsthand. Take, for instance, someone who's paid nearly $6,000 over the span of a year plus pre-trial process, then to have the funding bill take effect only within a couple weeks left before their trial date, at which, by the way, their case was null pros, dismissed, only to continue to have them have a conviction-free record. That won't happen again if this bill is extended. HB 1011 offers a fix to the immediate problem in several respects. It continues funding to indigent individuals to either pay private home detention fees or require local jurisdictions to waive or cover public home monitoring programs. This is huge. Make no mistake about it, home detention is still a version of incarceration. A judge has to order it just like any other type of release. An individual can't leave their residence except for any judge-approved allowance programmed into a GPS device. Many people on home detention are on 24/7 lockdown with no exceptions. However, you can have some semblance of a regular existence. Home detention meant the difference between life and death as COVID made its way through jails and prisons. We've seen unprecedented delays in trials across the state, stretching out to nearly 2 years, and jury trials are still currently on pause until March 7th.
Mr. Oppenheim,
yeah.
Need you to begin to wrap it up, please.
Okay. Secondly, it's an important step for the legislator to take towards reworking this entire pretrial system. It's inequitable across the state. Some jurisdictions, like Baltimore City and surrounding jurisdictions, don't have free home detention pretrial. Others do. This provides funding so that everyone in the state can. And make no mistake about it, our clients of color are disproportionately affected like this. Neither your place of arrest, your financial wherewithal, nor your race should determine whether you're held in jail as you await trial. Remember, this is pre-trial presumed innocent. Thank you.
Brian Levy, please, for 2 minutes.
Chairman Clippinger, members of the committee, thank you. My name is Brian Levy. I'm an attorney in the Youthful Defendant Unit of the Office of the Public Defender, where I represent juveniles who are charged as adults. Imagine you are the parent of a teenager charged with committing a crime. You learn that under our state's current laws, though presumed innocent, your child is automatically charged as an adult. You learn that there won't be a hearing to determine whether their case should be transferred to the juvenile court for several months, and that a trial date won't be set until even after that. You learn that until that time, the court has ordered that your child be held in detention unless someone can pay for them to be placed on electronic monitoring. As a parent, wouldn't you do anything you could to get your child out of pretrial detention onto that electronic monitoring? The parents of my clients don't feel any differently, but too often a desire to free their children is overcome by their financial inability to do so. Too many times I have witnessed parents tell their children, "I'm sorry, you can't come home because I can't afford it." Too many times I have received calls from clients' mothers stating, "We can't afford our son's home detention fees if this case gets postponed again," asking me then whether their child will have to go back to jail, not due to any failure to obey the conditions of pretrial release imposed by the court, but due to their inability to pay for it. When this legislature provided funds last year to pay for indigent defendants' home detention fees, it was a godsend to the children and I represent and their families. It was progress towards a system that I know we all believe in. That is a system where people are treated the same, regardless of their wealth or place of residence. Courts should not be limited in choosing among pretrial release options based upon a defendant's ability to pay for them. Let's not go backwards on the progress we've made. I'd ask you to please issue a favorable report on this bill. Thank you.
Christopher Dews, please, for 2 minutes.
Fantastic. Members of the committee, my name is Christopher Dews, and I'm the Senior Policy Advocate of the Job Opportunities Task Force. As always, our mission is to help lower wage workers advance to higher wage jobs. We support House Bill 1011 to ensure that indigent persons are not pushed further into debt or incarcerated while participating in privatized home detention. Just a little bit of stats, 9.9% of Marylanders live below the federal poverty line, making it even the smallest payments of criminal justice debts a real problem, specifically when it comes to privatized home detention, which differs based on your jurisdiction. Now, Montgomery County, for example, pays for all home detention through their pretrial services program. In January of 2021, we saw that Baltimore County moved to do the same after they saw a 30% increase in fees paid by individuals on private home detention. In Baltimore City, it's a bit of a different story. ASAP Home Detention will charge an individual roughly $300 to $500 a month to participate in their court-ordered home detention program, not including setup fees, taxes, or other extraneous charges. If an individual fails to pay, they can risk incarceration or violating the conditions of their release and fall further into debt. As was previously mentioned, this very committee passed legislation last year to establish a program that was going to cover the cost for these indigent persons. The judiciary, under the phenomenal leadership leadership of Chief Judge Morrissey, created a very powerful program that actually covers the cost for lower income persons. And just to explain how it works for 5 seconds, if you qualify for public defender, if you choose to have a public defender, you are automatically enrolled into the program and the payments are just covered. If you roll with a private attorney, then you would basically put paperwork towards the district court commissioner's office. Once you've done that, they send you a qualification letter. You send that qualification letter to your private home detention monitoring agency, and it's covered. It's a phenomenal program. It helps out. It's already helped 400 Baltimore City residents per month, saving over $300,000 not being siphoned from the community. So we just want to see this program extend. We don't want to see it end in June of 2022. It's very effective, and we want to see it continue. For those reasons, we ask for a favorable report.
Very much. Nicole Hanson-Mundell, please, for 2 minutes. Nicole Hanson-Mundell. She's entering the room. Nicole Hanson-Mundell.
My apologies, Mr. Speaker.
You're fine. Go ahead.
Chair. I am, definitely here to support this bill. Nicole Hanson, Executive Director of Out for Justice. We want to ensure that our family members and friends, individuals who are pre-trial, not yet convicted of anything, has access to this funding. I know that this was a huge support to our family members and friends and community. I know that this impacted the lives of people. This legislation and you all making sure that this happened was almost like a life or death situation for many community members. Folks had to decide how they were going to support their family members while also deciding how they were going to eat and pay their rent and pay their car notes and pay for bus passes. And so, I want to commend you all for the work that you did, those tireless days and nights trying to figure this thing out. And you all did a good job. And let's keep it up. Let's keep leading the way on how we show up for individuals who are pre-trial, not yet convicted of anything. These individuals have the presumption of innocence. And if nobody knows that, I know you do, Mr. Chair. And so for those reasons, I ask that you continue these efforts to support Delegate Stephanie Smith's legislation. Thank you.
All right, are there questions for this first panel? Any questions for the first panel? Seeing none, that's fine. We thank you all for testifying today. We're going to go now to a second panel, and the vice chair is going to step into the chair for a moment. We'll hear from Danielle Winchester, Kim Haven, Frank Boston, Malik Barnes, and Elena McWilliams. That'll be fine. Let's hear from that group of people. All right. So I'll pass it to the vice chair. I'm going to step away for a moment. I'll be back in a moment, and we'll go from there. If she's available, Danielle Winchester, please. Danielle Winchester, please.
I think we got to skip to Frank Boston.
Then let's do that. We'll go to Frank Boston then, please. And why don't we add Michael Sanderson then to this panel? We'll go ahead and add him to the panel in case there are a couple people who dropped off. Frank Boston, please, for 2 minutes.
Yes. Hey, good afternoon, Mr. Chair, members of the committee. I'm Frank Boston III. I'm here on behalf of ASAP and Alert. We are the home monitoring companies that do a lot of the home monitoring in the state. I do know Danielle was prepared to testify, and I know she's looking to testify. So hopefully you can circle back to her because she is the expert. And I just want to say that we support the bill. It is definitely necessary, and thank you for putting in. We are team players and we understand the goals of the legislation. We are here to be a resource for the committee and for the entire process. You know, after all, we live and operate in this space every day. We are the actual monitoring companies that this legislation definitely touches and concerns. Just for the record, in case Danielle does not get to testify, we are team players. I mentioned that, but the committee should know that we have not been paid anything yet, not one dime. We know that the judiciary is working diligently to make this happen, and we appreciate that, but we continue to provide the services without the benefit of being paid yet. We know it's coming, and so we'll be patient. And with that, that's pretty much all I want to say. We just wanted to be here today so that we can answer any of your technical questions, logistic questions, or any questions you may have as to how it works, how we operate, and how we're operating it under the legislation. Tim Slosh is the president and CEO of Alert. Daniel Winchester is vice president of ASAP. And I'm hoping Danielle's on because she is the true expert and I'm not me. That's my testimony, sir.
All right, thank you very much. Yeah, we don't have some of these folks on, including Danielle, so we'll try and get them on and stick them back in if we can. But next we'll go to Elena McWilliams for 2 minutes.
Hello, my name's Elena McWilliams. I'm here representing Out for Justice. I'm here in strong support of House Bill 1011. I won't reiterate all of the powerful statements that my colleagues have put forth, but I just would like to emphasize that, yes, we believe the current system that charges folks, or prior to this passage of this recent bill, the system that applied these home monitoring fees disproportionately burdened folks who had lower incomes and also disproportionately burdened people of color in Maryland, because we know, especially Black and Latinx Marylanders, they are disproportionately taken up into the legal system at every stage of the process and treated more harshly at every stage of the process. And if we layer on burdens, financial burdens to be free prior to one's conviction, that just exacerbates existing inequalities. And then lastly, we just want to highlight that paying these fees is much cheaper than housing folks when they can't pay these fees. So for instance, in Baltimore County, paying these fees is about $538,000 a year. To incarcerate that same group of people would cost $3 million a year. So if we're charging fees that people can't pay and then in turn paying to incarcerate them, that's not a good financial deal for Maryland either. So we're here in strong support and we hope you will favorably report on this bill.
All right, thanks. Next, we'll hear from Michael Sanderson for 2 minutes.
Thank you very much, Mr. Chair, committee members. I'm Michael Sanderson with the Maryland Association of Counties, also in support of the bill. We've submitted written testimony. I won't reiterate things you've heard from others. Candidly, this is one of these vexing issues that we actually have on the right track. So we're very grateful to the sponsor for recognizing we're about to run out of time on the current program. The bill to extend it is a great bill. We encourage a favorable report.
All right, are there any questions for these three witnesses? Don't appear to be any. Thank you, everybody. We will now bring in Yolanda Gregg, Janiyah Brown, Kiana Johnson, Marianne Lima, and maybe Crystal Williams, if she's there. Do we have Yolanda? Okay, let's we'll start with Yolanda Gregg for 2 minutes whenever you're ready. Okay, we might not have Yolanda Gregg. Do we have Janiyah Brown? Yeah, see Janiyah Brown for 2 minutes whenever you're ready.
Thank you, Vice Chair Moon and members of the committee. My name is Janaea Brown, and I am the pretrial logistics coordinator with Baltimore Action Legal Team and a resident of District 40. I am here today to testify in favor of House Bill 1011. Since November of 2020, I've been responsible for managing BALT's bail and electronic monitoring funds, tracking payments, and liaising with clients. Weekly, I receive requests from Baltimore residents who are at risk of violation for non-payment. Distressing requests came and still come from all directions, from juveniles to the elderly, from those with mental health disorders or physical impairments, from single parents struggling to make ends meet, or those that unexpectedly lost work during the pandemic. As 2021 progressed, I was growing near to the point where I would have to begin turning people away, and because the funds would just exhaust too quickly. But I never wanted to make that call because people had their whole lives on the line. When July 1st came, I can't lie, I was selfishly relieved that half of my caseload would be off my plate, despite the program not beginning till October 1st. Although the state has taken a portion of my caseload away, we have now been busy fielding requests from individuals with private attorneys who are still struggling to make ends meet, as well as requests for post-conviction support because judges are now assigning private home detention sometimes instead of the Department of Corrections program. As I sit here today, BALT has spent nearly $300,000 of community funds on electronic monitoring support. With daily rate increases, that number is only set to grow. If this bill does not pass starting in June of this year, there will be many individuals that will need to come back to BALT for funds, still awaiting trial because they have no other options. As much as we want to be there to help, it won't be possible to support everyone, and I just can't be okay with taking that chance. The state has the resources to extend this program and can spend the next 4 years designing a better solution than private home detention for those waiting their day in court. I urge a favorable report from this committee. Thank you.
Thank you very much. Now we'll have Kiana Johnson for 2 minutes. Kiana, looks like you just muted yourself. All right, why don't we skip to Marianne Lima for 2 minutes?
Thank you. Good afternoon, members of the committee. My name is Marianne Lima. I'm an attorney with the Public Defender's Office, and like my colleagues before me, the office does request that this committee issue a favorable report on House Bill 1011. I'm in a unique position as I am in the central booking office of Baltimore City, and my role is distinctly based on pretrial challenges. So I've seen firsthand how vital this program has been in reducing unnecessary court proceedings and addressing the overuse of pretrial incarceration, and ensuring that people are able to continue to care for their families and avoid accumulating debt while they, again, are presumed innocent. I do have several examples of successful clients that would have been incarcerated for several months had it not been for the program. One was an 18-year-old with no prior arrest that was discharged with false statement to an officer and multiple traffic infractions. But for this program, his family would not be able to afford it. Like my colleague, Mr. Levy, said, that's an all too common occurrence here. Another client of mine was a 38-year-old woman who has been deemed unable to work since 2013, but she has no prior convictions and was just primarily charged with conspiracy crimes that she denies having any involvement with. But for this program, she would have been incarcerated for 35 days as of the day of this hearing. While my focus is on Baltimore City, we do see that it has helped other jurisdictions as well. In some jurisdictions, judges would never consider home detention for someone who is deemed indigent and therefore would revert back to just hold without bail. Other jurisdictions along the state border, this program has allowed for at least one client to be on home detention who unfortunately resided in a bordering state, since the pretrial services program in that jurisdiction did not allow for out of state client supervision. I've also noted that in addition to having the earliest instance of release on home detention, it's also reduced subsequent litigation. Prior to this program, we'd have the issue of people not being able to afford home detention. It would require multiple motions and multiple hearings by multiple attorneys for relief to be sought and granted. This this bill has greatly alleviated that burden, and has, not had all the attorneys required to continue seeking relief for these clients based on unaffordability. So for all these reasons, again, the bill has added a trusted option for the judiciary to release, not just with those with financial means, to be able to get supervision and be out on the streets while awaiting trial. So for those reasons, we're asking the court, this committee to issue a favorable report. Thank you.
Thank you very much. Kiana Johnson, were you able to get your audio going? Okay, no, we do have Danielle Winchester back, I believe, from an earlier.
Yes.
Okay, Danielle, you have 2 minutes whenever you're ready.
Thank you. I apologize. I just switched computers when things went glitchy. I thought it was my laptop. Hi, my name is Danielle Winchester, and I support this bill. I am the Vice President and Program Director for Advantage Sentencing Alternative Programs, also known as ASAP Home Detention. I've been the Program Director for 28 years. During this time, we've monitored tens of thousands of defendants. We are licensed by the Commission on Correctional Standards and Public Safety and audited to ensure that we are following state law. We have passed every audit and have never had our license suspended. We work closely with the courts to ensure public safety and that the defendants are doing only what there is allowed by the court order. Our program is tailored to each judge's order. I even have judges' cell phone numbers to alert them immediately upon violations. We report all violations to the court set forth by COMAR. We testify often in hearings and assist the state's attorney's office and police when a warrant has been issued. We work with all counties in the state of Maryland, and the state funding program for indigent defendants is used not only by Baltimore City, but by all counties. When a pretrial client is enrolled in the program and they're qualified through the commissioner's office as indigent, and their home detention is then paid for by this program. This program has not been without its difficulties with regard to getting paid. We feel the judiciary has been working tirelessly to ensure invoicing is done properly and the required paperwork is received. Although we have not yet been paid, I am assured that this will happen, and it's a matter of time, as opposed to the state approved people, having people approved through indigency, or that the state doesn't have funding. I can assure you that this issue is not compromising the safety of the public. I look forward to working with the work group and taking a deep dive into these issues. I'm happy to answer any questions. Thank you.
All right, thank you very much. We have one question from Delegate Anderson.
Yeah, thank you, Mr. Chair. Ms. Winchester, first of all, let me thank you for the dozens of my clients that you've put on home problems with the phone or the connection, things like that. So you guys do a great job. And I give you that compliment ahead of time because I want to ask you a tough question. And that is with a state funding, with the court funding this, and you're going to end up getting hundreds, if not thousands of more clients. Does the state catch a break in terms of the costs compared to what it was?
Yes, actually, that's not a difficult question at all. My program, and I can only speak for my program, not other companies, but my program has always discounted public defender clients since our inception. So we discount it. We also ensure that we give extra time for payment when it was paid through by the defendant. So yes, we understand the difficulties.
Okay, and you're still up there on Joppa Road?
We are. We're additionally opening other satellite offices, one being Baltimore City, since it is such an important part of this program.
Yeah, that's what I was asking. If this program is going to go with the public defender funding, we probably need to get a satellite office a little closer into Baltimore.
Yes, actually, I had a satellite office for years, actually right next to the courthouse. And with COVID, we dropped back, but didn't realize that we were going to grow with this program growing. So yes, we will be reopening. I actually have an office being looked at now.
Okay, thank you very much.
Of course.
All right, next we have a question from Sandy Bartlett, Delegate Bartlett, excuse me.
Thank you. This question is for Ms. Winchester. I believe we talked about this in previous years, but is the internet required to be able to utilize the home monitoring system?
Not with my program. We use GPS monitoring. We feel that's the best way to monitor individuals, regardless of the cost. It does cost me more money, but I feel like public safety is much more important than me saving a couple of dollars.
Right. Okay. Thank you. And so thank you for that. So is a phone line necessary?
No, ma'am.
Okay, great. Thank you.
Delegate Anderson, is your hand still up from last time? I'm gonna guess it might be. All right, we've got some of our missing witnesses are here. We've got Yolanda Gregg. Yolanda, if you're ready, you got 2 minutes. Yolanda Gregg, are you able to connect?
Unmute and turn your camera on.
Oh God, where did he go?
Start talking. Unmute, turn your camera
Good
on.
afternoon.
We
Hi,
can
how
hear
are
you. We can hear you.
You can hear me?
Yeah, just go ahead. You have 2 minutes.
Oh, okay. Well, my name is Yolanda Vaughn Gregg, and I am actually on the pretrial ASAP home monitoring detention program. They are charging me $500 per month while waiting trial. There is no way that I could afford those fees on disability and get ready to have open heart again. However, the courts has been assisting me far as the fees, helping to pay the fees. So what I'm asking is that if this program could actually stay in place, because I know for me it's really actually helping me. And I know like 3 colleagues that when they didn't have the money and it built up, they had to go right back in because they didn't have the money to pay, for the home monitoring.
All right, thank you very much. Do we have any questions for this witness? All right, I believe that is the end of testimony on House Bill 1011. We're going to go next to House Bill 1053 from Delegate Williams and Shoemaker. And I believe this one is jointly assigned with ECM. So we are joined by our colleagues from that committee, Delegates Harrison, Brooks, and Mounts. Delegate Williams has a couple witnesses, David Morris, Ari Plout, and Jocelyn King. Delegate Williams, you have 3 minutes whenever you're ready.
Good afternoon, Vice Chair Moon, members of the committee. I am testifying today in favor of House Bill 1053, also known as the Kelsey Smith Act of Maryland. I heard that former Chair Valero used to say, speak from your heart. And so this is a bill where I'm just going to speak from my heart. As some may know, back in August of 2020, a good friend of mine, Joseph Lynn Kitchen, was found deceased after being reported missing for 8 days. He was from Fresno, California, and moved to the DMV area here to continue his higher education and pursue his dream of teaching. He embraced Maryland as his other home, but made it very clear California was still his birth home. But since he didn't have any family here, he always kept in close contact with his family by always keeping his cell phone on his person. He was an Apple guy, so he always had his iPhone and his iPad with him. So it was very peculiar when we couldn't get a hold of him after a certain amount of time, and days went by where we just hadn't heard from him. And so as one of his friends and his family, we grew very concerned very quickly. We had contacted law enforcement and filed a missing persons report. We did provide the police with all the information that we had regarding Joseph's last known whereabouts and his last location. And law enforcement went through all of the proper legal channels to obtain a warrant and to try to ping his phone for an approximate location. Unfortunately, by the time law enforcement was able to obtain the information, Joseph's phone was dead and law enforcement was unable to ping the device. The Kelsey Smith Act is named after Kelsey Smith, who was a young woman who was kidnapped, sexually assaulted, and murdered in 2007. She had a cell phone, but law enforcement was unable to obtain her cell phone's location from the telecommunication services provider until more than 3 days had gone by. Her family has since established a foundation in her name and have worked to enact legislation in 30 other states with bipartisan support, including Washington State, New Jersey, Pennsylvania, and Hawaii, just to name a few. The goal of this bill is to assure that really this does not occur again and that another parent will not have to experience the pain and suffering that they endured with the loss of their daughter Kelly, or that I endured with the loss of my friend Joseph. This bill is seeking to only obtain the physical location of a cell phone and have that information available only to law enforcement. We've spoken with a number of advocates. There are some amendments that are forthcoming to kind of deal with some of the issues that arose, including concerns that were raised by Verizon and some of the other telecommunication carriers, and just to kind of add some additional safeguards and protections, such as a judicial review and some other amendments. And so I apologize that we don't have the amendments today, but they will be forthcoming to the committee. And it's for these reasons I urge that this committee give a favorable report to House Bill 1053. Thank you.
Thank you. The chair is back. We have one witness here, Mr. Chair, Ari Plout.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, esteemed members of the committee. My name is Ari Plout, and I'm here on behalf of the Maryland State Fraternal Order of Police, here in support of House Bill 1053. Thank you, Delegate Williams, for sponsoring this legislation. We support this bill because we believe that it will save lives and it will protect public safety. This bill will enable law enforcement to locate potential victims of kidnappings, suicides, other missing people by providing information about their location. Locating these individuals will often require immediate action. Without the legislation, there may be lengthy delays in obtaining this information, and unfortunately, it can be too late when it is obtained. I'd also like to point out that the information released is limited only in exigent circumstances, and also the bill is limited in scope and how long the location information may be obtained, which is only for 48 hours. And with that, I appreciate your time, and I ask for a favorable report. Thank you.
Thank you very much. So I'm assuming that David Morris and Jocelyn King, are they not here? They're not in the waiting room. Okay. Are there questions for this panel? Any questions for this panel? Delegate McComas, you're on mute.
I just want to know if Delegate Williams has had an opportunity to look at the unfavorable by the Office of Public Defender, and if she wants to make any comment on it or anything about it, that it ain't so.
I haven't had a chance to review it. I'm hoping, as I mentioned, we are going to put forth a couple of amendments, and so I'm hoping those amendments will address some of the concerns raised by the Office of the Public Defender. And I'll definitely circle back with them after the hearing today, just to make sure.
Well, just so you're aware that they're basically saying that the criminal procedure article already authorizes a court to issue an order, but I'm wondering if time is of the essence, and they're saying what I assume what's the time frame? 48 hours?
48 hours, yes.
Yeah, and there's no guarantee you'd get that right from the courts. Thank you.
Are further questions for the panel? Seeing none, we thank you very much. And that concludes the testimony for House Bill 1053. Okay, we're going to go now to House Bill 957. And there are several people set to testify here. We will. Okay, well. All right, well, this is Delegate Williams's bill. So we'll hear from Delegate Williams, the State's Attorney from Prince George's County, Aisha Braveboy, Nicole Hanson-Mundell, Kiana Johnson, Kim Haven, and Christopher Dews. And then we'll go to another panel after that. So Delegate Williams, please, for 3 minutes.
All right, good afternoon, Mr. Chair, members of the House Judiciary Committee. I am here testifying in favor of House Bill 957, also known as the Criminal Procedure Expungement of Felony Convictions. This legislation would allow for an individual to file a petition to expunge police and court records of convictions for first-degree assault if it's not related to a domestic violence case, and if the individual does not have any prior convictions, also for carjacking and for armed robbery. There's a wide range of social and economic costs associated with having a criminal record that shows up in one's lifetime, even after they have done their time incarcerated. While varying from state to state, some professional licenses and accreditations, such as those to be required to be a real estate agent or a dental hygienist, are unattainable for those who have a felony conviction on their record. And the lasting effects of a criminal record, also known as collateral consequences, have severely inhibited an individual's well-being and their opportunities that could have been available to them over their lifetime. This legislation, there's been similar legislation to this bill that's been passed in other states, such as Indiana, just to name a few. And by passing this legislation, individuals who have served their time and have not committed any further offenses would have the option to seek to clear their records after a significant period of time has passed. And there is in the testimony that's been uploaded, there is an infographic that kind of highlights the percentages of how this affects people in their life in some of the other states that have enacted this type of enacted similar legislation. And so we, here in Maryland, we have tried to work over the last couple of years to really just afford people a second chance in life. And this bill, I think, is just seeking to continue that work that we have done over the years. And so you will hear from others on my panel about why this bill is so important. And for these reasons, I urge this committee to give a favorable report on House Bill 957.
Right. Let's hear from the State's Attorney for Prince George's County, Ms. Braveboy.
Thank you so much, Mr. Chair and members of the committee, and thank you so much to the bill sponsors. This bill really is about restoring individuals who have proven that they are no longer a threat to our communities. And it is really important that we provide every pathway we can for individuals to be successful in life. As was mentioned, this bill expands the current scope of offenses eligible for expungement, again, after a waiting period of 15 years where that individual has not committed any further offenses. 1 in 3 adults have a criminal record. A record can be just the arrest itself, criminal charges that are filed, or a conviction. And what we know is that having a record impacts an individual's ability to obtain housing, government benefits, citizenship, employment, and opportunities for higher education. And so it's really important to us that we recognize that people can and do change. And when they come to we have started to have several expungement fairs, and when they come to our expungement fairs and we're able to really help so many people, what really disappoints me, and I'm sure disappoints those who are participating, is when we can't help them. When they say they made a mistake, they understood that they made a mistake, they paid their debt to society, they've been clean for years, some of them 20 plus years. They have families, they are fathers, grandfathers, mothers, sisters. These are people who live next door to us who can't, fully, take advantage of all that life has to offer because they feel really held back by having a conviction for a crime that today they would not commit. So we're just asking that we join states like Michigan, as well as Indiana, as was mentioned, and other states that have recognized that expanding opportunities for expungement is critical and important to assist individuals who have otherwise shown that they can be safe and live good lives in our community. So we just ask for your favorable consideration of this bill. Thank you very much.
Nicole Hanson Mundell, please, for 2 minutes. Nicole Hanson Mundell.
Apologies again, Mr. Speaker. This is the life of a working executive director. My name is Nicole Hanson Mundell. I am the executive director of Out for Justice, an advocacy arm that impacts and is led by formerly and currently incarcerated individuals, those individuals who this piece of policy impacts today, as it has for us all today. We are here in support of Delegate Ms. Nicole Williams, and also our State's Attorney Aisha Braithwaite out of PG County. We appreciate the special eye on the different ways that the criminal legal system impacts people, especially those like myself, like Ms. Kiana Johnson, who are committed to working with individuals who are hard at work rebuilding their lives. They deserve your attention. They deserve for you not to conflate the rhetoric in our society today that says, lock them up, lock them up, lock them up, lock them up, lock them up. We know that the research shows that does not work. And so I am, asking many of you new elected officials to join us and look and being able to determine the difference between over incarcerating and finding ways to support those individuals who have committed their lives to rebuilding their lives. They have families, we have families. We need relief on the ground, and this is a piece of policy that gives that relief. This is a piece of policy that you'll be able to go back into your districts and talk about to your constituents who are like me, who have a criminal records and have rebuilt our lives. And you can say, I engage in policy that supported you. I engage in policy that trickles down to your family. And so we need this relief. We need to ensure that we get some of these felony convictions expunged. Maryland is really behind in terms of the time limits that how long it takes to get your record expunged. And so let's be on the right side of the law. I understand that there's crime happening, but there's also another side. There are thousands of Nicole Hanson Mundells. There are thousands of Kiana Johnsons. There are thousands of us, and we are relying on you to do the right thing and level the playing field. Thank you, Mr. Chair.
Thank you. Kiana Johnson, please, for 2 minutes.
Yes, thank you to the members of the Judiciary Committee and the sponsors of this bill, and for the leadership of Madam State's Attorney Braithwaite for bringing this bill forward. My name is Kiana Johnson. I am the founder and executive director of Life After Release. Life After Release is a women-based, formerly incarcerated-led organization. We vow to provide at-risk and formerly incarcerated women of Prince George's County with an opportunity to overcome the barriers that often plague women of color after being released from incarceration. I am also a member of the National Council of Incarcerated and Formerly Incarcerated Women and Girls, and I'm fully in support of HB 957. As many of you know, Maryland has an incarceration rate of 531 per 100,000 individuals, meaning that it locks up a higher percentage of its people more than any democracy on earth. What is more disheartening is that according to the Justice Policy Institute, more than 70% of people in Maryland's prison, double the national average, and almost 80% of those individuals serving at least 10 years are Black. What this means is that this state is more invested in causing further harm rather than finding restorative approaches to harm caused in our communities. As a result, its residents are more likely to see the inside of a prison cell than to be given a diversion opportunity to address the lack of resources or access that leads them to commit a life of crime in the first place. This bill is a step in the right direction for the state of Maryland to rectify the harm its criminal legal system has caused over the last 20 years that has disproportionately impacted families that look like me. Currently, Maryland's unemployment rate is at 6.8%, which is an increase from 3.5% in 2019 and only 1.9% under the national unemployment rate. These numbers are a direct reflection of the leadership within the state to provide jobs and employment opportunities. Passing HB 957 will enhance the pool of applicants by allowing people to expunge their records and apply and qualify for jobs that they would not have been able to in the past. It is time for Maryland lawmakers to understand that economic justice is at the heart of public safety. If we want to truly have hope in this state, we must take action to divest from locking up its residents and invest in bills such as this one that will provide people with records a chance at a quality of life that is worth living. It is highly unlikely that a person will rob someone on their way to work. Lastly, Life After Release is doing its part. Our state's attorney is doing their part. What is the committee doing their part? Thank you.
Thank you. Christopher Deuce, please, for 2 minutes.
Indeed. Thank you, Mr. Chair. My name again is Christopher Deuce, for the record, Senior Policy Advocate, Job Opportunities Task Force, where our mission, as always, is to help lower wage workers advance to higher wage jobs. Mainly, this is done by removing barriers to employment. As has already been mentioned, a criminal record is both the cause and consequence of poverty. It becomes a massive barrier to employment, 1,100 collateral consequences for having a record. Even if it's a non-conviction, PBJ have said it's a huge issue. So of course, this bill is going to be an expansion on what is allowed to be expunged. To be clear, the maximum penalty, for example, for first degree assault, I want to say, you guys are lawyers, you know better than I am, but than I do, 25 years. Right? 25 years. And then there's a 15-year waiting period tacked onto that if this bill were to pass. Right? So right now it's not even expungible, but if this bill were to pass, 25 years maximum penalty plus 15. For the record, that's 40 years, if I do my math correctly. 40 years ago, Eye of the Tiger by Survivor was the #1 song in America. That's the amount of time that an individual is going to be waiting before they can get this record expunged. I would argue that if an individual it's been since the Eye of the Tiger was the #1 song, the chances of them probably reoffending and recommitting is, let's just say, rather nil. JLTF, of course, by that logic, is going to support this legislation. Any legislation that's going to reduce the waiting periods as well. And also, as was already said in this committee before, any legislation that's going to allow for the automatic expungement of non-convictions as well. I just want to throw that out there because I know that's a bill that you guys have been discussing as well. So that being said, it's all about giving access to employment for us when we look at this angle, and we know that people change. It's 40 years is a very, very long time, just as an example. For those reasons, we ask for a favorable report.
Are there questions for the panel? All right, seeing none, we thank you all very much for your testimony. Matt Parsons, Netra Williams, Marianne Lima, and Judith Danso, please. Start with Matt Parsons. Matt Parsons, please, for 2 minutes.
Yes, thank you, Mr. Chair and members of the committee. My name is Matt Parsons, and I'm the community lawyer with Baltimore Action Legal Team. I'm testifying in support of this bill. This bill directly addresses the disproportionate harms Black and Brown communities incur from the restrictions on expungement eligibility. I see these harms firsthand as a community lawyer. Most often, clients are those seeking to overcome the economic barriers from having a criminal record by seeking expungement relief. If you've personally had a record, you'd know exactly how this affects your daily life. If you haven't lived this experience, though, this is what it means. Being regularly rejected for jobs with livable wages on irrelevant grounds because of employer bias. Failing to qualify for support services, which could help you find stable housing, for example. Also struggling to provide for yourself and your family, not to mention future generations. Though this is plainly obvious, and others have stated this today, this is a socioeconomic dilemma that our public policy is frankly apathetic towards. If you can't maintain employment, it's difficult to find stable housing and vice versa. Without either, poverty is basically imminent, and someone becoming a repeat offender and recidivism occurring out of sheer economic desperation is almost inevitable. So to reiterate, this bill will still place the usual restrictions on expungement eligibility for felony convictions. So for individuals convicted in 2020, this means they wouldn't theoretically be eligible to even apply until 2035 earliest, and only if they're not convicted again in that entire time span of 15 years. In this light, the bill isn't actually asking for much. It is just seeking to restore the economic and social rights of many. This is not only a legal issue, but also a moral imperative and an issue of human rights. There are zero compelling reasons not to support this bill. And so I urge a favorable report on House Bill 957. Thank you.
Thank you very much. We'll hear from Netra Adams, please, for 2 minutes. Go ahead. We can't hear you. You might be better off disconnecting. She needs to connect to audio. All right. Why don't we can go to Marianne Lima from the Office of the Public Defender. We'll go to her and then we'll come back, okay? So Ms. Lima, please, for 2 minutes.
Thank you, Chairman and members of the committee. The Maryland Office of the Public Defender requests that the committee issue a favorable report with amendments on House Bill 957. It's vital that we continue the trend of increasing the availability of expungement services to Maryland residents. Expungement, as we all see, is so important when it comes to allowing all individuals to move beyond mistakes and subsequent convictions that may follow. Our clients generally seek expungement to help secure a job, a professional license, or certain types of housing, which are all basic fundamental needs. So generally, the public defender does support this bill, but we would encourage that the limiting language be stricken dealing with the first-degree assault under Maryland Criminal Code 3-202, that the person have no prior convictions prior to being eligible for expungement. We feel that the language does not promote the purpose of the bill, and that a minor non-violent conviction could prevent or delay this more serious charge from being eligible, which would lead to an absurd result. So for those reasons, we're asking that the committee issue a favorable report with the amendment on this House bill. Thank you.
Thank you. Let's go back to Netra Adams, please. Ms. Adams.
She said she had to call in.
All right, let's do this. We'll go to Judy Danso. We'll keep trying to work with, wait, maybe? Ms. Adams?
Do you all hear me?
Yes, go ahead for 2 minutes.
Awesome. Apologies for the technical issues.
Go ahead.
I wanted to say good afternoon, members of the committee and witnesses. I wanted to thank you all for your time and consideration and open-mindedness. And I am here to testify in favor of House Bill 957. Because first and foremost, we are a nation both of accountability for wrongs, but also the ability to correct those wrongs. Life is not always simply black and white. There are a multitude of gray areas, and I have lived most of my adult life in those gray areas. I've endured my fair share of mistakes. I've been immature, I've been reckless, and I've been careless. My history is not one that I'm proud of, but it is mine nonetheless. It has molded me into a person of understanding and compassion, understanding that we all fall short in some capacity, in some aspect throughout our lives, And that's the beauty of growth. The fact that one stupid decision or one bad night or one bad patch of immature years could prevent one from ever experiencing what it feels like to land that dream job. I've missed out on a few. Or never knowing the experience of moving into that perfect neighborhood. I've been denied a few times. Or keeping you from being loved because you can easily be searched on Google and all your past pains and stupid mistakes are laid bare for the world to see. I'll never forget the slew of questions I endured that date night, nor the sunken state in which it left me. We, not only as a nation, but as a people, are not limited to who we once were. We have the ability to remedy those wrongs, and this bill grants a person the ability to start fresh. I am now a mother to 5, a grandmother to 1, simultaneously a student and a full-time employee. I'm a contributor to our society, an active member of my community. I even try to find the time to volunteer when I can. Again, I want to reiterate, we are not limited to who we once were. Anyone can make a stupid mistake. I've made a few, but that shouldn't condemn me for life, for I am no longer the girl in the mugshot. I am no longer the uncontrollable drunk. Allow me and others like me the grace and God-given ability to be who I was destined to be without the weight of those mistakes haunting me. Again, I am in favor of House Bill 957, and I thank you for your time.
Thank you very much. Judy Danso, please now. Judy Danso.
Thank you, and good afternoon, Chairman Clippinger, Vice Chair Moon, and distinguished members of the Judiciary Committee. Good day also to Delegate Williams and Delegate Tolles. For the record, I am Judith Danso, Chief of Staff in the State's Attorney's Office for Prince George's County. I'm also an Assistant State's Attorney, and I'm grateful for this opportunity to be here today to express strong support for House Bill 957 and the expansion of the scope of offenses. As a former defense attorney who has tried cases at both the state and federal level, I prided myself on offering pro bono services for expungements to all of my clients in criminal cases who were eligible to proceed the course. I also spent significant time writing letters to potential employers explaining the effects of a PBJ because I understood the significant value in this and what impact it would have for one to be successful at the end of the expungement process. In my current role, I not only oversee the management of the expungement affairs within our office, but I also actively participate in the oversight process for the petitions filed daily by the many residents in our county that seek a second chance in life and greater opportunities to become productive citizens. And we certainly do, for the record, oppose those where necessary. But as Madam State's Attorney Brave Boy mentioned, as one can imagine, unfortunately, individuals with criminal records face major barriers to employment, housing, and education, effectively condemning them to second-class citizenship. I think on today, you will certainly appreciate and have heard from several of those individuals and advocates alike who will speak to their personal challenges and experiences and the various hurdles that cannot be overcome because of something on their record from many years ago. There is significant research and data that exists in support of expansion to this end, particularly when it comes to the fears and concerns of recidivism. I know the University of Michigan conducted a very detailed study confirming alarmingly low rates of such, in addition to research in criminology that indicates that people with records who go several years without another conviction, in this case 15 years, are unlikely to reoffend. I can tell you personally that of the several people that I've come in contact and connected with at the many expungement fairs our office has put on, the majority have had no subsequent contact with the criminal justice system, or it is far removed from their initial conviction or the present and simply desire to get their lives back on track. So on today, members of this legislative body, I urge a favorable report on this bill to expand second chance and greater opportunities for those who have proven some level of rehabilitation. Thank you.
Thank you. Are there questions for this panel? Seeing none, we thank you all very much. That concludes the testimony in favor of the bill. We'll now hear from the opponents to the bill. Stephen Kroll, Joe Riley, John Cox, Vince McAvoy. Mr. Kroll.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and the Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases since 1984 in opposition to House Bill 957. If you look at the crimes that House Bill 957 says, it is first-degree assault. That is serious physical injury. We refer to it as shock trauma injury or a crime with a handgun. Second, we look at robbery with a dangerous and deadly weapon, which is on here also. Robbery with a dangerous deadly weapon, most likely a gun. And third is carjacking. Imagine a mother with a child who gets their car carjacked. What the proponents fail to mention are the victims of crime. Those victims of crime live with this every day. They're the victims who suffer economic consequences, physical consequences, and mental consequences. Those are the ones we should think of. The first priority of this legislative body is to think of the victims of crime and not the defendants. And for those reasons, we are opposed to House Bill 957 and ask for unfavorable report. Thank you.
Joe Riley.
Thank you, Chair Clemenger, members of the Judiciary Committee. My name is Joe Riley. I'm the elected State's Attorney for Caroline County and the Legislative Chair for the Maryland State's Attorneys Association. We seek unfavorable report on this bill. One of the proponents of the bill said there is no societal benefit to having these charges remain on your record. I would like to propose one. The access to firearms. Why would there be any reason that this body would want a person who has been convicted of robbery with a handgun or committing assault with a handgun to would someday have access to firearms? I cannot think of any fathomable reason that that would be the policy of this committee. But also on the other end, does an employer have a right to know that an applicant has a prior conviction for armed robbery when they're considering putting them next to other individuals as a salesman or in any other form of, don't they have a right to at least have that basic information? And as for the sense that it would be 40 years from now, while I appreciate the theme song for Rocky III being sung, no one gets 25 years and serves 25 years day for day. We know that even if they got a 25-year sentence, they're going to be paroled in 12 and a half. And so that's not really a fair summation of how Maryland sentences people. So this bill is altogether bad, and we seek unfavorable report.
Mr. Cox, please, for 2 minutes.
Thank you, Chair Clippinger, although I noticed a couple of times you were Mr. Speaker today. And Vice Chair Moon, members of the Judiciary Committee, I'm John Cox. I'm Deputy State's Attorney in Baltimore County, to echo our opposition or ask for an unfavorable report with regard to House Bill 957. For those of you who have been here for 6 years, you remember all of the work that we went through in 2016 concerning justice reinvestment. Criminal Procedure 10-110 was a major part or a significant part of that Justice Reinvestment Act, in which this legislature went through every single crime that can be imagined in the state of Maryland to consider whether or not to apply an ability to expunge to a guilty finding. And they came up with an exhaustive list of those which would be eligible. We then jumped to in 2018 to adding a few felonies, theft and burglary, I believe it was. And now all of a sudden we're going to, other than murder and rape, we're going to jump to allowing expungement of the most violent crimes that one can imagine. And it is a circumstance where it just isn't right that we remove all memory of somebody having stuck a gun in somebody's face or shot somebody or stabbed somebody. The public ought to know about what this individual has done. We'd ask for an unfavorable report.
Vince McAvoy for 2 minutes, please.
Thank you so much, committee. The bill talks about expunging assault, carjacking, armed robbery. Except Stevie, because we know that the domestic violence advocates camp outside your office, or maybe it's that the delegates are looking at this from the perspective of who it would affect. There might be horrors that a domestic violence victim wouldn't experience that a carjacked mother would with children in the back. That happens in city a lot. What also happens in the city, I'm going to relate a personal example. I want to talk about the change that you all are saying happens with people. There was an incident where two men with guns, large guns, tried to rob me, beat me about the head. They were after a gold chain. They didn't get it. They ran off. I would later run into that guy. He turned out to be a father, and I would actually help him with his child support issues. And I recognized him. I don't know that he recognized me, but the thing that stuck that he told me, because, we're giving testimony in his father's rights kind of element. He said, I'm a gunman, and I guess I'm always going to be a gunman. And these type of bills, when you look at page 2, it goes to page 3 and page 4, and this will always get expanded on. I urge an unfavorable. These kind of bills shouldn't be brought. We have a lot more issues than giving criminals a free ride when they've hurt somebody. I went to the hospital. Other people that are suffering assault, armed robbery, they're going to the hospital. They're losing days' wages. Okay, this is just insufferable that we keep looking out for people who have no interest in helping society and will harm us at the drop of a dime. Again, he was a good guy. Don't get me wrong, but he's a gunman. He'll always be a gunman. Thank you for your time.
The Vice Chair for questions for the panel.
Thank you, Mr. Chair. This is a question for the state's attorneys, really. I actually do understand, the concern that they're flagging, but I guess I want to ask whether your intention, and I guess what you're comfortable with, is having a system where essentially there's never the possibility of forgiveness or consideration of the personal circumstance. Someone's changed after some time, that by law there's no opportunity for that sort of redemption on their record. And I suppose that's where we leave things. And so to me, that's a little bit of a disconcerting place to land. And so I just want to ask, if there's some amount of amendment that we could at least start talking about this, because I think it does raise interesting policy problems. A firearms amendment, a longer timeline. I think it's 15 years under existing law for the more serious offenses to expunge, but I don't know, 20 years, 25 years, and we take out firearms. You have the opportunity to object, I believe, in the bill and in existing policy. And so I guess, is there some room for us to build that opportunity for redemption into the system? And if not, I know Mr. Kroll raised the victims. I guess I have to ask, what's the victims' interest in that continued public shaming, seemingly indefinite beyond the terms of supervision or parole or probation potentially? What's the public interest in that?
Well, if the records aren't going to be permanent for armed robbery, now this is armed robbery, not robbery. For some reason, robbery is not on this bill, but armed robbery is. Carjacking and first degree assault, which again is assault with a firearm, if they're not going to be permanent records, what is going to be a permanent record? I just don't understand why there is such a need to have the community unaware of the prior criminal history of an individual when we're talking about.
Never, no one ever? You can't think of a single person that could have changed in those 25 years?
I didn't say they couldn't change. I just said that people have the right to know what they have done. And if they want to make a decision that, hey, I've met you personally, I've gone through all of your history, and I think you have changed, and I'm going to give you this job opportunity. Okay, fine. But this bill says I can't know about it, which I think is an unexcusable amount of ignorance, especially when you could potentially be endangering everyone who you work with and everyone else you employ.
Are there further questions for this panel? Delegate McComas.
My concern is that, all right, let's say we pass this, there's no guarantee that an employer who hired somebody would not still be subject to a civil suit of negligent hiring.
Absolutely, they would. 100%.
And I guess the other question I have is, how's it going to affect law enforcement? I mean, if a person has had a history of being violent, let's say an armed robbery and using guns, or maybe even stealing some guns to commit a crime, what's the guarantee? I mean, don't they need to know that this person has a history of violence before they approach them?
I would think that would be an important thing to know before they make decisions as far as, let's say, pre-trial release. Let's say an individual qualifies for this, gets their record expunged, and unfortunately goes out and commits another offense. When we make a pre-trial release determination, wouldn't it be nice to know that they have a conviction for armed robbery before we make that decision? Probably. So I agree with you, Delegate.
And just real quick, the way you read the bill now, is it that the police are not going to have any of that background? The commissioner's not going to have any access to that? The judge isn't going to have any access to it because it's expunged, which means it's like it never happened, right?
That's my understanding of what expungement does. And keep in mind, it would for armed robbery, but not robbery, which I really don't. If the intentions of the advocates for this bill, I just don't understand it at all.
Thank you.
Further questions for the panel? Seeing none, we thank you all very much. And that concludes the testimony for House Bill 957. We're going to go to our final bill for the day, and that's House Bill 958. We're going to hear from Delegate Williams, Aisha Braveboy, the State's Attorney, Prince George's County, Elizabeth Hilliard, Becky Feldman, Erica Suter, and Doyle Neiman on the first panel. We're going to hear from them to begin. It's 3 and 2, so this is the last bill of the day. I'll gently mention that the words "me" and "two" are always helpful towards the end of the day, but you know, a guy can dream. Delegate Williams for 3 minutes, please.
Thank you, Mr. Chair, Vice Chair Moon, and members of the House Judiciary Committee. It's me again, Delegate Nicole Williams, testifying in favor of House Bill 958, known as the Post-Conviction Review Motion for Reduction of Sentencing. This legislation allows the state's attorney to file a motion to reduce the sentence of an incarcerated individual if a lesser sentence is in the best interest of justice. In the state of Maryland, there are approximately 36,000 individuals currently behind bars, and with people of color being disproportionately affected and disproportionately make up the majority of that number. This state is no stranger to, unfortunately, mass incarcerations and strict mandatory minimum sentences, which we have worked out over the years to eradicate. This bill will simply allow the state's attorney of the jurisdiction where the criminal case's sentencing took place to ask the court after a period of time to reconsider a sentence for an inmate if they believe that it would be in the best interest of justice to the individual and society as a whole. This bill will offer a second chance to incarcerated individuals after they have proved themselves to no longer be a risk for perpetuating future violence. Multiple factors must be taken into consideration when petitioning the court, including an inmate's disciplinary record, a record of rehabilitation, any evidence that shows that age or time served has lessened the likelihood of future violence, and whether or not an individual's circumstances have changed since the inmate's original conviction. And this is not a decision that would be made lightly by the court, but one that would be made with the best interests of everyone in mind. Incarcerating has a devastating effect on the individual, their families, and their community. And if someone has put forth the effort to change and better themselves during the time of incarceration, it would be injustice to not revisit their original sentence and to rob them of a chance of a new future. I think this bill goes to a theme that we have done over the past couple of years towards that effort. And for these reasons, I urge this committee to give a favorable report to House Bill 958.
State's Attorney Braveboy, please, for 2 minutes.
Thank you so much, Mr. Chair, Mr. Vice Chair, and distinguished members of the Judiciary Committee. I am here today to express strong support for House Bill 958. This bill provides limited discretion to state's attorneys for the purposes of filing a motion to modify a sentence during any period of active incarceration. This bill establishes the factors that the court should consider, including the inmate's disciplinary record and record of rehabilitation and maturity while incarcerated, evidence that reflects whether age, time served, or diminished physical condition has reduced the inmate's risk for future violence, and evidence reflecting a change in circumstances since the original conviction and sentencing that the inmate's continued incarceration is no longer in the interest of justice. As state's attorney, my job is to seek justice and accountability. I'm also required to do so in a way that is fair, just, and equitable. I've been very concerned about the racial disparities that exist within the incarcerated population here in Maryland. In its 2019 report, the Justice Policy Institute provided data showing that more than 70% of Maryland's prison population was Black, compared to 31% of the state population. Among those serving the longest prison terms, 10 years or more, 82% of those individuals are Black. The purpose of the criminal justice system is to protect society, punish offenders, and rehabilitate. While we focus, as we should, on protecting victims in the community, providing consequences and accountability to those who commit offenses, we must also recognize when an individual has been successfully rehabilitated, and they should be provided with an opportunity to join our community, and the justice system should be recognized for its work in assisting for the restoration of individuals in the system. My office established the Conviction and Sentencing Integrity Unit specifically to evaluate those cases where lengthy sentences have been imposed. While the legislature has provided a clear path to review sentences of juvenile lifers through the Juvenile Restoration Act, and I want to applaud this committee on their work, the same path does not exist for young adult offenders or those who have served decades or more in prison and are no longer a threat to our community. Passage of this bill would give prosecutors the best flexibility to provide opportunities for restoration for individuals who have proven that they are rehabilitated and are ready to be productive members of our community. Thank you.
Thank you. All right, Becky Feldman, please, for 2 minutes.
Good afternoon, Chairman Clippinger and members of the committee. My name is Becky Feldman, and I'm the chief of the Sentencing Review Unit, and I'm speaking on behalf of the Baltimore City State's Attorney's Office. Prosecutors are the most powerful players in the criminal justice system. And over time, laws have evolved, our practices have evolved. There is a better understanding now, a more evolved understanding of juvenile behavior, drug addiction, and poverty. Also, as prosecutors, we need to be mindful that we have a mass incarceration problem and an aging inmate population problem. And like Madam State's Attorney Braveboy just said, we are also aware that racial disparities exist in our system. And for these reasons, we have, as an office, began evaluating our own prosecution practices for racial inequities so we can do better. So with this context, my Office of Prosecutors wants to be responsible and should be responsible for ensuring that sentences of people who are still serving time in prison continue to be fair and reasonable under our most current standards. This type of review is not within the parole board's purview. This law would permit prosecutors to request a sentencing hearing in cases where we agree that a reduced sentence is in the interest of justice for any number of reasons. And we need a procedural vehicle to do this work. And for any prosecutors that do not want or need this tool, they don't need to use it. This is not a requirement that offices create sentencing review units or establish any type of procedure for doing this work. But I'm here on behalf of the Office for Baltimore City. We incarcerate more people than any other county in Maryland, so we have a greater responsibility. Thank you all for the opportunity to testify in support of House Bill 958. Thank you.
Thank you. We'll hear now from Elizabeth Hilliard. 2 minutes.
Good afternoon. Thank you, Chair. Thank you, members of the committee. I will heed your advice, Chair, and say me too to everything that Ms. Feldman and Ms. Braveboy just said. And I will just note, in my other capacity at the Public Defender's Office, I work in the post-conviction unit. I know firsthand how heartbreaking it is to represent someone who is elderly or who has served well beyond decades in prison. And despite both myself as their public defender and the state's attorney on the case, wanting there to be a way to reevaluate the sentence or to give that person an opportunity to speak on their own behalf to a judge about reevaluating their sentence, there's no mechanism in place. Post-conviction is tricky, it's legally focused, and it is in no way meant as a safety valve for those who have rehabilitated themselves, who have served their time, and who are ready and suitable to be released into society. It's not a sufficient mechanism, and our mass incarceration and our aging prison population demonstrate that. We need better systems in place, and this is one of them. We urge a favorable report on this bill, and thank you very much for your consideration and your work on the Juvenile Restoration Act. Thank you.
Erica Suter, please, for 2 minutes. Erica Suter. Okay, what about Doyle Neiman?
Thank you, Mr. Chairman, Vice Chairman, members of the committee. I'm Doyle Neiman. I'm speaking in two capacities today. One as the chair of the Legislative Committee of the Criminal Law and Practice section of the Maryland State Bar Association. You have our written testimony in support of this bill, and also as a 24-year prosecutor in the state's attorney's office in Prince George's County, where I now am in charge of the sentence review unit that the state's attorney mentioned. But I'm also speaking as a former delegate. So one of the things I learned in my time in the House was to not let the perfect get in the way of the good. And what this bill does is it threads the needle. And that's something that I think is rare and very important. It addresses a serious problem. People change, times change, but sentences don't change. And they're rarely, after a certain 5-year period, there's really no clear mechanism to make that happen. But it also does it in a way that addresses the criticisms that have been raised, the issues that have been raised by past efforts. And this committee has had several. Eric Barron had a second look bill 2 years ago. And last year, the Court of Appeals and the Rules Committee of the Court of Appeals put forward a proposal that would have essentially opened up the reconsideration process to a much larger population. And there were criticisms raised of that. And so this bill addresses those criticisms as well as the positions that have been stated in the past by even some of my colleagues in the state's attorney's offices and other jurisdictions about the impact on victims and the flood of cases. And it does it in a way that is creative and workable and makes sense by putting the state's attorneys in charge of the process. Now, there are some who would say, well, don't limit it that way, but saying that putting the state's attorney in as a gatekeeper is going to prevent a flood of cases that are not ever going to go anywhere. That was a big concern of the Court of Appeals last year when they did not act on, but did not reject the proposal to transform the reconsideration law. And it also addresses the concern of some of our colleagues who talked about, cases coming in and people having to appear over and over again. So for those reasons, I suggest this is a good way to thread the needle and address a problem and make a real difference. So thank you for your attention and your work and your incredible patience.
Thank you very much. Erica Suter appears to be back on the line and in the room, so we'll hear from her for 2 minutes now, please.
Thank you, Chairman Clippinger and Vice Chair Moon and members of the committee.
My name is Erica Suter. I'm the director of the Innocence Project Clinic at the University of Baltimore School of Law and president-elect of the Maryland Criminal Defense Attorneys Association. I'm here to testify in support of House Bill 958 and to tell you about a client who would be impacted by this bill. This client is serving a life sentence for felony murder. She's currently almost 60 years old, recently had emergency bypass surgery. She suffers from a host of medical issues, including a recent diagnosis of kidney failure requiring dialysis. Despite entering prison with a drug addiction, she got sober and she's maintained her sobriety over the past 25 years. She's maintained a perfect infraction-free institutional record. She was recommended for parole by the Parole Commission and denied by the governor. There is currently not a procedural mechanism to get her back into court. Through no fault of her own, she missed her post-conviction deadline, which generally precludes her from filing a post-conviction now or a motion to reopen. Her sobriety presents a challenge to filing a motion for drug treatment. She doesn't have an illegal sentence. She is simply an aging, ill, vulnerable Black woman who is completely rehabilitated and no danger to society. This bill would empower the state to seek relief where appropriate in cases such as hers, despite what we hear every session about the double-digit number of ways for defendants to have their sentences revisited. I've practiced in this area of law for almost 15 years, and it's simply not the case. I would love to say that this client's case in this posture is an anomaly, but it's not. I would urge this committee to issue a favorable report on this bill. Thank you.
Questions for the panel? We'll go to Delegate Anderson first. Delegate Anderson.
Yeah, thank you very much, Mr. Chairman. Thank you, Ms. Delegate Williams, for the bill. My question is going to be to State's Attorney Braveboy. Thank you so much for showing up and testifying today, ma'am. In the bill, and maybe my reading might have been too quick, but I didn't notice anything in the notice section where you say that the inmate himself or herself should have notice of the hearing. Is there going to be notice given to the victim, if in fact there was a victim in that particular case, or should we amend the bill, or do you see the State's Attorney's offices actually doing that on their own?
Well, we are required to do that by law, by the Victim's Bill of Rights. So we, and I'm sure most or all offices are required to. So I'm sure that that's the rule that we all follow, that we notify victims at every stage of any type of criminal proceeding where they are involved in some way. So we will continue to do that. I don't know if that specific language has to be in this bill. If it does, certainly, by all means include it. But yes, that is the intent, is to ensure that victims are notified.
Okay, thank you.
Are there further questions for this panel? Seeing none, we thank you all very much for your testimony today, and we'll go to our next panel. David Jaros, Lee Goodmark, Kim Haven, May Lim, Christopher Dews, and then we will stop there. That's fine. Then we'll take, it looks like a third panel. So David Jaros, please. I see you, Mr. Jaros, please, for 2 minutes.
Thank you. Good afternoon, everyone. I will try to be quick. My name is David Jaros. I'm the faculty director of the University of Baltimore School of Law's Center for Criminal Justice Reform. The Center for Criminal Justice Reform is dedicated to supporting community-driven efforts to improve public safety and address harm and inequity in the criminal legal system. And we are grateful for this opportunity to testify in support of House Bill 958. This is the kind of common sense criminal justice policy that improves public safety, serves the needs of crime victims, and creates a valuable opportunity to revisit sentences that may no longer be appropriate and to reverse some of the ill effects of mass incarceration. Now, I've submitted written testimony, so I'll confine my comments to just a couple key areas, and I mostly will say me too to everything else that's been said. But I want to say it's important to note that the narrative that crime victims always want longer sentences is false. A national survey on crime victims' views on safety and justice found that the majority of victims believe the criminal justice system should focus more on rehabilitation and less on punishment. And a majority of those surveyed favored a system in which sentences like this could be shortened, even for people serving non-life sentences for serious and violent offenses if they were deemed a low risk to public safety. Finally, I just want to add that HB 958 makes the criminal process more transparent and consistent. The bill provides much needed clarity on courts' jurisdictional authority to hear prosecutor-initiated resentencing motions. While there are a variety of procedural and constitutional avenues that fit individual cases, as we just heard from Erica Suter, this bill simplifies and clarifies the process by which a court can consider a prosecutor's motion to resentence. When everyone involved, the prosecutor, the defense, the victim, and the court all believe resentencing is in the interest of justice, there should be no doubt that the court has jurisdiction to correct an inappropriate sentence. That being said, and because time is limited, I want to thank you all for the opportunity to testify in support of this bill.
Lee Goodmark, please, for 2 minutes.
Thank you, Mr. Chair and members of the committee. My name is Lee Goodmark. I am the director of the Gender Violence Clinic at the University of Maryland Carey School of Law. The Gender Violence Clinic represents incarcerated survivors of violence, people who have been incarcerated for crimes related to their own victimization. And like Ms. Suter, we have many clients who could benefit tremendously from this bill, clients who have served 10, 20, 30 years, clients who have shown extraordinary change over that time, and clients who no longer need to be incarcerated. In our written testimony, we talk about one of those clients, a woman named Dorena Pretty, who you may remember served 42 years before we were able, with the help of the state's attorney, in partnership with the state's attorney, to help her get free. But we were lucky in that case that there was a legal hook to get her back into court. In many of our cases, as Ms. Feldman said, there is no such legal hook. There are just people who have changed, who no longer need to be incarcerated, and who for whatever reason cannot get back into court. And so for those reasons, we strongly urge the passage of HB 958.
Thank you very much. Kim Haven not in the room, so we'll go to May Lim, please, for 2 minutes.
Good afternoon. My name is May Lim. I'm the Senior Policy Associate at For the People. We are a national organization and we support prosecutors who are working to review past sentences that are no longer in the interest of justice. Our organization is led by Hillary Blount. She's a former prosecutor who wrote California's Prosecutor-Initiated Resentencing, or PIR, law. It's very similar to HB 958, and they both provide prosecutors a direct, streamlined way to address instances where a person's serving an excessive or unjust sentence. So California's PIR law took effect in 2019, and then Washington State, Oregon, and Illinois followed suit shortly after, and they've since passed PIR laws of their own. And like the existing 4 PIR laws, the proposed bill in Maryland is not a mandate, but rather is discretionary. So state's attorneys can opt in if they would like to, and they don't have to if they would not like to. They can make the decision that's in the best interest of the communities that they've been elected to serve. The bill would give state's attorney the discretion to look back at sentences on a case-by-case basis. Some sentences that were reasonable and appropriate during sentencing may no longer be just today, given changes in sentencing practices and new research that we have today. This bill would give prosecutors another tool to carry out their duty of advancing justice both at the time of sentencing and after. And it also ensures that each specific case is carefully considered before moving forward and puts into place a series of checks and balances. So while the prosecutor has discretion, victims' voices must be considered, and the judge ultimately has the final decision-making authority. So to end, I'd just like to share how the law is working in California. We have 58 district attorneys across the state. About a dozen have opted into using the law, and the others simply have opted out. Those opting in include Riverside, Yolo, and San Diego counties, which just demonstrates the wide range of counties that have jumped on board. So there's large, medium, small, rural, urban counties on board with prosecutors from across the political spectrum. Over the last 3 years, there have been about 100 people who have been resentenced and released because of that very methodical review I mentioned. And while that number has been modest, it's certainly been meaningful and impactful. Thanks, delegates, for your time.
Thank you very much. Christopher Deuce, please, for 2 minutes.
Indeed. Thank you, members of the committee. Again, for the record, my name is Christopher Deuce, Senior Policy Advocate, Job Opportunities Task Force. And in the spirit of goodwill, I am going to say me too.
Thank you very much. Extra points for Chris Deuce. We'll stop right there. Are there questions for this panel? Seeing none, thank you all very, very much. And we'll go on to our next panel, and I think we'll go through the remainder of the favorable. So Mike Hilliard, Elena McWilliams, Robbie Leonard, Nicole Hanson-Mundell, Jasmine Hines, and Keith Wallington. We could have those people brought in. We'll start calling them for 2 minutes. Mike Hilliard, please, for 2 minutes.
Thank you, Mr. Chair. My name is Mike Hilliard. I'm a member. I spent 27 years with the Baltimore Police Department, rising from patrol officer to major. I am here to support HB 958, which would allow prosecutors to initiate post-conviction reviews. As a speaker for the Law Enforcement Action Partnership, or LEAP. LEAP is a nonprofit group of police, prosecutors, judges, and other criminal justice professionals who speak from firsthand experience. Our mission is to make communities safer by focusing law enforcement resources on the greatest threats to public safety. The most important barrier I see to law enforcement reducing violent crime is the cooperation of the community. Without communication from the community, we cannot prevent crime and we cannot solve crime. Our detectives depend on information from witnesses to come up with leads, understand what happened, and close cases. We need the trust of community members. HB 958 is a step in the right direction to help Maryland officers regain that trust. This legislation would allow the state's attorney to review past cases, and if it serves the interests of justice, recommend a reduced sentence for an incarcerated person. These individual case reviews would contribute to restoring faith in the criminal justice system. I cannot overstate how important the community's faith in the criminal justice system is to the police's ability to protect and serve. We also know that shortening unnecessarily long sentences reduces overcrowding and frees up criminal justice resources to focus on those who really do pose a public safety risk. Some people change and can be rehabilitated. We must reserve our limited prison space for those who threaten our safety. Having the opportunity for sentence review would also incentivize positive behavior in prison. Allowing prosecutors to conduct post-conviction reviews is the right thing to do for incarcerated individuals, for communities, and for Maryland's criminal justice system.
Mr. Hilliard.
We thank you for your time today and your opportunity to speak on this important issue.
Thank you. Elena McWilliams, please, for 2 minutes.
Hello, my name is Elena McWilliams. I'm here with Out for Justice. I'm here in support of House Bill 958. I will broadly say me too, but I will also add that there's a parallel here between the state having an opportunity to right its wrongs by looking back at some of the sentences it may have assigned before the state knew better about what justice could look like. Similarly, folks behind the walls who have done a lot of work to overcome some of the traumas, some of the influences and addictions that they may have experienced early in their life, they also deserve a second chance at freedom, at contributing to their communities. And as a therapist of 15 years, I have walked that path with numerous people who served long sentences behind the walls and came out and worked with me and gave back incalculable ways to their communities. We are losing out when we do not give folks second chances. And I urge a favorable report on House Bill 958.
Robbie Leonard, please, for 2 minutes.
Thank you, Chairman and members of the Judiciary Committee for having me today. Thank my good friend Delegate Williams for sponsoring this much needed legislation for prosecutor-initiated resentencing. My name is Robbie Leonard. I'm a principal attorney at Leonard & McLiggett Law Group, a private practice with cases all over the state of Maryland. I'm also a candidate for Baltimore County State's Attorney. It's an honor to testify alongside Prince George's County State's Attorney Aisha Braveboy, the Law Enforcement Action Partnership, and several law school professors, among others. Now, we can have safe communities when we have an effective justice system. And the justice system can only be effective when the community has faith in every aspect of it, including in sentencing. And the community knows that we can do better. To do better, we must act differently. That's why places like Prince George's County is a conviction integrity unit. Baltimore City has a sentencing review unit founded by former State's Attorney Greg Bernstein. I don't think that we have anything like that in Baltimore County, but we should, and we will. Montgomery County State's Attorney's Office recently began a 2-year process to investigate prosecutorial decisions in the county and determine whether they are racially biased. Well, what if Mr. McCarthy learns that his sentencing recommendations for Black defendants or Hispanics were greater than white defendants? What can he do about it? The purpose of sentencing is to advance public safety through punishment, rehabilitation, and restorative justice. When a sentence includes incarceration, this purpose is best served by terms that are proportionate to the seriousness of the offense and provide uniformity with the sentences of offenders committing the same offense under similar circumstances. House Bill 958 allows a prosecutor to initiate a resentencing. This is not an additional bite of the apple for a defendant. This is not another means for a defendant to request a reduced sentence or to have a conviction overturned. This is strictly and solely a tool for a prosecutor to pursue justice. In many situations, it's the prosecutor who will have access to specific information where he can make a decision to have his sentence revisited. And that state's attorney should have the ability to make that request. But even with this bill, no one is being forced to take action. If a prosecutor in one jurisdiction wants to maintain the status quo, he can. This bill gives each prosecutor a choice. I ask the committee to give a favorable report. Thank you.
Thank you very much. Nicole Henson-Mundell, please. Don't see her in the room. Jasma Hines, please. Do not see Jasma Hines. Keith Wallington. Keith Wallington, don't see Keith Wallington either. All right, then we'll take, well, we may get Keith Wallington, so hang on. Here's Keith Wallington. Mr. Wallington? Mr. Wallington?
Yes.
That's fine. You can testify for 2 minutes on the bill, okay?
Thank you so much. I don't know if you are getting feedback because I have, unfortunately, I think I'm.
We can hear you. You have to close the YouTube link.
Okay. I'm sorry. I'm still listening, Mr. Leonard.
Okay. Mr. Wallington, are you ready?
Yes.
Go ahead for 2 minutes, please.
Thank you so much. And I'll make it short. JPI has supported similar legislation in the past. I'm sorry. Yes, can you hear me?
You have to close the YouTube link that you were using to watch the testimony.
Okay, it's closed now. Can you hear me?
All right, now we can hear you. You should hear us.
Okay, I'm sorry about that.
For 2
Thank
minutes,
you so much,
please.
Thank you so much, Mr. Chair. I won't take 2 minutes. I appreciate the time today. JPI has supported similar legislation in the past. I'm sorry, my name is Keith Wallington. I am with the Justice Policy Institute, a national nonprofit organization dedicated to improving outcomes for individuals who've been involved in the justice system. JPI has supported similar legislation in the past. Supporting this bill is very consistent with work we have done, which show that people who get out under similar scenarios have very low recidivism. The UNGers with the recidivism rate of about 3% were released similarly as a result of court action and have gone on to be a model for the country, showing that we can safely release long sentence individuals without compromising public safety. This bill will not open up the floodgates, as the state will have the ability to identify the cases that are being considered. So for this, we ask for a favorable report on House Bill 958, and thank you so much for allowing me to speak.
Thank you. We'll take questions now for this panel. Delegate Cox.
Thank you, Mr. Chair. This question is for Mr. Leonard, if he's still on the line.
Yes,
thank
sir.
you, Mr. Leonard. Good to talk to you today. Real quickly, does the bill as drafted allow for those convicted of first-degree rape of a minor with a mandatory life imprisonment or first-degree murder, mandatory life sentences? Does it allow for those to be revised?
This bill does not specify any crimes that are included or excluded.
So the answer is yes, it does allow for that, correct?
It's true.
Do you support that?
I support this possibility of having a prosecutor look at any specific crime, any specific sentence, to give an assessment as to whether any laws or sentences are being racially biased, gender, ethnicity, whatever it is. It's a case-by-case basis.
Well, currently under 4435, I think it is. If I don't practice this very much, so I can't remember the rule, but there's already a motion to revise if there's a mistake or some fraud or irregularity for something like you just mentioned. So this would be just for any reason as listed in the bill, isn't that right?
Correct. This is a prosecutor-initiated resentencing.
Okay. Thank you, Mr. Chair. Nothing more.
Delegate Williams.
Yes, Mr. Leonard, under this bill, the prosecution would have to file a motion with the court that is subject to judicial review. Is that correct?
That is correct.
Okay, and then the final arbiter of whether or not such a motion should be granted would be the court itself, correct?
That is true. And the set of factors for the court to determine is listed within the bill.
It is, okay. Thank you. Thank you, Mr. Leonard.
Thank you.
Further questions for the panel? Okay, that concludes the testimony in favor of the legislation. We thank you all very much. We'll hear from the opponents to the legislation now. Steve Kroll, Joe Riley, Vince McAvoy. See Mr. Riley first, so we'll hear from Mr. Riley first, please.
Thank you, Chair Clevenger, Vice Chair Moon, distinguished members of the Judiciary Committee. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the chair of the Maryland States Attorneys Association Legislative Committee. We seek an unfavorable report on House Bill 958 that grants the state's attorney an incredibly awesome power. And despite the fact that you heard testimony from two offices, we are not asking for it. In a vote of 22-2, we do not want this power. Please do not give it to us. And I would like to address some of the things that were said in the proponent's testimony about avenues for this type of relief. And I'll tell you about a case that we had in Caroline County. Darrell Williams was arrested for undercover sale of crack cocaine in the amount of $20. He was immediately released after that on a pretrial release and went out and did it again and was arrested on a subsequent day. He was tried and convicted in both cases and had subsequent offender penalties. He received 40 years on each one consecutively, a total of 80 years. When I became the elected state's attorney in 2018, Mr. Williams wrote to me and I went through his case and I worked with his defense attorney and we went through a post-conviction and Mr. Williams is today released from prison on his sentence. So there are avenues for this type of thing to exist. I would also think about cases where the sentence was life without parole. If you have a state's attorney's office who they get a sentence of life without parole, they talk to their victims and they say, you'll never have to worry about this case again. Well, what happens if that state's attorney loses? And the state's attorney who comes in says, I think life without parole is a violation of the 8th Amendment, cruel and unusual punishment. And I think this person deserves to have a resentencing. Well, that victim has to be brought through it all again, even though they were told not to. And I know people are going to say, well, the victim has a right to be heard. Not if you look at this bill. On page 2, line 10, the things the court may consider, and it goes through the court, things the court may consider. If you read legislative things frequently, then you would know that the court may not consider the things that aren't there. What isn't there is the statements of the victim. They may not consider them. It is not something they can look at. So there is no victim impact statement on any of these cases. Now, I know Delegate Moon likes to ask me these types of questions of, is there ever any sort of thing that could imagine? While we are opposed to this bill, that doesn't say that we're never opposed to this bill. I encourage Delegate Williams to speak with our committee and talk about if there are some amendments that we can talk about as far as types of crimes.
Right.
Get this to be drug crimes or crimes and eliminate crimes with victims. If we can talk about types of sentences, taking out life without the possibility of parole. Can we talk about exhaustion of other remedies.
Mr. Riley.
And I just have one more sentence. And if we can talk about adding the things that the Rules Committee had, as you heard other proponents talk about, as far as amount of time that the sentences has been in before they are eligible for this. Let's talk about this. Let's work this out. And maybe we can find something that we can all agree with to allow us to have this awesome power. Thank you.
Steve Kroll.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting since 1984, and we are in opposition to House Bill 958. Victims get no closure. Victims get no closure. There is no right for a victim to appeal. In all my years, and they've been a lot, I can't tell a victim when I first started the case is over, because it's not. A new state's attorney can change it. These same arguments were made in 2019 when at that time, Delegate Eric Barron sponsored House Bill 598. It passed. Now the arguments are the same. The proponents are the same. At that time, they called it vacatur. Now it's called modification. This bill puts politics into the procedure. This bill puts politics into the process. For example, Jurisdiction A has an elected that will listen to special interest, big donors, or friends of a defendant and review certain causes like life without parole or serious cases that occur. Jurisdiction B has an elected that thinks all gun cases are bad. Guns should be legal and will modify all gun crimes, including ghost gun cases, or might not believe in domestic violence crimes. There is no uniformity in this bill, and this committee has said to me over and over, we want uniformity. There is none. This bill also enhances racial disparity. What do I mean? Racial disparity in the following situation. Jurisdiction A has an elected that prosecuted a case. The defendant is from the area. He's a person who is not of color. He gets a sentence. Another defendant who is a person of color gets the same sentence. One defendant has close contacts with the state's attorney. They get the modification. The other person does not. Racial disparity in the making. Finally, the answer to the question is the parole board. The parole board can solve these problems. The state's attorney can write. The judge can write. Anyone can write to the parole board to get this matter heard and corrected. That is your answer. This committee had no problems with the parole board when it took the governor out of it. The parole board is accessible. The parole board will hear the case. Now, as Mr. Riley has said, Delegate Williams, and I know I'm rushing through this, but I want to make it clear to Delegate Williams, we want to talk to you about this bill. We believe we could come to some sort of an agreement, and we welcome your opinion. So we will have a board meeting on Thursday, the beginning of March, and we will come to you with at least at that time some suggestions. And for those reasons, the way it's written right now, we are opposed to House Bill 958 and ask for an unfavorable report. Thank you.
Vince McAvoy, please. 2 minutes.
Thank you so much, committee. I urge an unfavorable on this. I don't like the posture. I don't like the trend. As we just saw in the previous bill, there's a focus on somehow getting people released. I want to talk from an economic perspective for just a moment. Released to what? We have tens of millions of people who are out of work as jobs are evaporating. What are they going to come out to? You're going to release these people. You're thinking that you're doing them a favor, and you are not. What are they going to do when they get out? So this issue, like Hogan said this, and I'd like every year that goes by, it seems to make more sense. It's focused on hugging criminals and disregarding the crimes that these people are doing to people. As I brought up in the previous bill, people lose days of work. People lose, parts of their body. And that's just not, where's the let's reconsider that. There's already motions to reconsider. Parole board, you just heard that. But these folks can write it on their own. When you look at the code and it says that the state prosecutor shall do this and the court shall do that, that's not the posture that we should be in. They've already been prosecuted. And this injection of making this political is going to be a mess. So the horrible instance where each person recognized by a state's attorney or each class recognized or somehow in a political favored stance will be subject to political pressures. And if not, what's going to suffer? Public safety. Again, these folks are not just, they got convicted in a state where we're routinely letting convictions go, combining convictions and just taking one out of 11 or 12 charges that they have. This is not a good bill. I hope that you don't work on this. This is just a poorly thought idea. Thank you for your time, committee.
Are there questions for this panel? All right, seeing none, that concludes the testimony on House Bill 958, and it concludes the testimony for the Judiciary Committee today. We'll be back tomorrow with still more bills, and that's just fine. That's what we do. Thank you all very much for your time and your attention today.